without my recognizance who otherwise have business before this court be held here in this chapel. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to the second day of our fall argument session here in our magnificent Harrisburg courtroom. As you may know, because I say it all the time, the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722, and in 2022, we celebrated our 300th anniversary with a special session in the old City Hall in Philadelphia. We on the court are very proud of our rich history. Over the past 26 years, I've had the privilege of sitting on the bench in this majestic courtroom with these beautiful murals by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Mural Project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ms. Oakley proved to be up to the task. Already a well-regarded artist from Philadelphia, Oakley's work in this building made her world-renowned. Her vision for this room was to write a book on the evolution of law, and the murals in this room will remind you of the pages in a medieval or Renaissance manuscript. Ultimately, she devoted 25 years of her life from 1902 to 1927 to painting the 43 murals in our Capitol. I trust that no one who works here takes this gift for granted. While there are many things that our three branches of government may disagree on, I know that our judiciary, along with our legislature and executive branches, all agree that we have been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent Capitol. I also wanted to mention that we marvel at the 52 million pound terracotta dome above the rotunda, a 1/3 scale model of the dome of St. Peter's Basilica in Rome, on top of which a 15-foot gilded statue named Commonwealth stands. The green and gold stained glass dome, designed by Alfred Godwin, is one of many domes in our Capitol, but this is the only stained glass dome, and it's only visible from this courtroom. Architect Joseph Houston intentionally placed this courtroom on the 4th floor with the legislative and executive chambers on the 2nd, both to physically separate and symbolically indicate that the judiciary is an equal branch of government. This courtroom was designed in the Greco-Roman style, as indicated by Ionic columns and the Greek grille wainscoting, all handcrafted. All of the wood in this room, including the bench, is mahogany imported from Belize. I'd also like to draw your attention to the bronze chandeliers, which I'm told but cannot verify each weigh 2 tons. They are unique yet different from one another. Under the main light in each is a statue dedicated to 4 great lawgivers. To my right are the Hebrew lawgivers. Closest to the bench is Moses, and in the back is King Solomon. To my left are the Greeks. Closest to the bench is Aristotle, and in the back is Solon, a foundational figure in Athenian democracy. Solon laid the groundwork for modern democracy by making laws fairer and expanding political participation. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we're all here to do. Now, we're fortunate to have some students visiting with us today. First of all, we have a group of 4th and 5th grade students from the enrichment program of the Don Gill Elementary School in the Wellsboro Area School District. These students are accompanied by Tioga County Commissioner Mark Rice, Tioga County Human Services Administrator Sarah Rice, the children's teacher Jen Spohr, and Justice Mundy's Judicial Assistant Nancy Clemens. Thank you, Justice Mundy, for arranging their visit, and would the children please stand so we can acknowledge them? Welcome. Glad you're here. You can be seated, and perhaps we have some future lawyers in the group. Also visiting with us today are 2 seniors from Bishop McDevitt High School, Liam Fuller and Gabe Brobson. They are escorted by Lauren Brobson, and I thank Justice Brobson, there you are, for arranging their visit. Would those 2 students please stand? All right. Liam and Gabe, welcome. You may be seated. We're always happy to have students here, and it puts the pressure on the lawyers who are arguing not to dissuade these students from pursuing a career in law. All righty, before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of your case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time I will ask that you conclude your argument. Mr. Minner, please call the first case.
Commonwealth of Pennsylvania versus Ricky D. Vance, representing Mr. Vance, Mr. Brooks Thompson, representing the Commonwealth, Ms. Adrian Jack.
In this appeal by allowance, we consider whether Google GPS location records may be admitted into evidence without authentication or testimony regarding reliability and accuracy. We also address whether a police lieutenant who lacked information regarding Google's proprietary algorithms and processes used in creating the GPS location records was permitted to testify as an expert witness regarding the records and to rely on the records in forming his expert opinion. Good morning.
Good morning. Thank you, Chief Justice Todd, and may it please the court, my name is Brooks Thompson. I represent Ricky Vance in this matter. Your Honors, the holding that we're requesting from the court today is simple but incredibly important to criminal cases arising in the modern era and in the future. And that is to say that before the Commonwealth may introduce evidence generated from an electronic process, such as here, Google location information, to convict an individual of murder, it must first present some evidence that that electronic process is reliable, that it produces accurate results, and that it was operating correctly on the date in question, as well as information about how that process works.
Counsel, could I ask you a question just at the threshold there? You mentioned deliberate accuracy.
Pardon me. Counsel, you mentioned reliability and accuracy, and you've done so in your brief. But 901 is simply that the evidence is what it purports to be. Aren't reliability and accuracy partaking more of weight of the evidence issues?
Well, Justice Wecht, I do agree that those issues are related. However, if we look at Rule 901 B9 specifically relating to the authentication process for electronic processes, there is a requirement in that rule that the proponent of the evidence present exactly what I just indicated, some information about how that process works.
It's Rule 902. 902.13.
Oh, that I was referring to 901B9. 902.13, I believe, is the rule that says the requirements of 901B9 may be met with a certificate rather than through testimony of a live witness. But under 901B9, those requirements are that the information, there be information about the process, that there's evidence that the process produces an accurate result, and that the process was operating correctly on the date in question. I believe that those matters do go to reliability, and this court expressed concern about establishing the reliability of electronic processes in its recent decision in Commonwealth versus Wallace. And the majority opinion in that court concluded that, or opined that the best way to do that, or the process for doing that, would be through authentication. Ultimately, obviously, that holding wasn't reached, holding on authentication wasn't reached in that case because it wasn't raised. But here we are. And I would submit that the Commonwealth has circumvented the requirements of 901B9 or the requirement of showing any evidence of reliability of this electronic process for this critically important evidence by admitting the evidence through the business records exception, and the trial court approved that, of course, and then the Superior Court approved of that procedure as well.
Counsel, you would agree that if the certification that was proffered met the requirements of 902.13, you'd be satisfied. And 902.13, as I understand it, requires a description of the process that was used, and what it requires is everything that someone would have testified to if they were in court.
Exactly, Justice.
So there's a way to avoid bringing in someone from Google. However, the certificate has to be detailed enough to give information that allows you the opportunity to test it and probe it.
Yes, Justice Donahue, I agree with that statement, and the comment of Rule 902.13 is clear. It says that the certification offered to prove the authenticity of an electronic process must contain all the information that would be required if that witness were to testify at trial. And in terms of the information that must be required, when we're dealing with an electronic process, that would be that which is required by 901B9.
Counsel, could you clear something up for me? Was there an objection to the Commonwealth's notice of intent to seek admission of the GPS records through Rule 902?
There was an objection on the record. There was not an advance objection.
There wasn't a motion in limine.
There wasn't a motion in limine.
But there was an objection on the record?
There was an objection in the courtroom, yes.
Is it on the transcript? Is it in the record?
Yes, it is. It should all be at, I have 24B of the reproduced record, 25B, and then 26 through 28B, 31B, and 117B. The objection was the Commonwealth sought to present the information. We objected first on the grounds of hearsay, because at that time it was unsettled whether the records were hearsay or not. But then we also included a second objection, authenticity, and we argued that the certification that the Commonwealth provided was not sufficient for a variety of reasons, but one of those reasons was that the certification was produced by a mere custodian of records talking about a complex process, about an algorithm for generating location information, which we submit if the person were required to come into court. In other words, the appearance wasn't excused by 902.13. If the person were required to come into court, that person we would generally expect would need to be required to be qualified as an expert to testify into
Counsel,
those.
let me interrupt you there, because that goes to the heart of what Justice Donahue was asking you about the certification. In my experience, trial experience, certifications that are kind of on a form never really substitute for proper cross-examination. If I'm defending the case and I want to challenge the GPS location data, how would I go about doing that? Or how would I go about having an expert testify if it's proprietary? In other words, if I can't get the information, my client says to me, couldn't be me, I don't know what happened, let's hire an expert. How do I challenge the admissibility of that particular information?
Well, that's precisely one of the problems with if the Commonwealth were to argue, well, you know, we gave advance notice, you didn't object to it, you could have presented your own expert to rebut this. We really couldn't, because even the Commonwealth's expert didn't have knowledge about the proprietary algorithm that Google uses. And what would be important in determining the reliability of this information would be the aggregate information that would only be maintained by Google as to, you know, the frequency with which this information is tested and how frequently is it accurate.
Could you have subpoenaed, sir? Could you have subpoenaed, or why couldn't you have subpoenaed such a Google person? And then if the Commonwealth filed for a protective order, you could have fought that out in the trial court and got a ruling on Google's proprietary claim.
I suppose that's something that we could have done, Justice Wecht. At the time, we weren't precisely sure what Detective Mitchell's testimony would be when he testified. And if in the record, you might note that when he was being qualified as an expert, I tried to press him on, you know, his knowledge of Google's processes. It became very clear during that section of the examination, I submit, that he didn't know anything about the processes, and then he acknowledged through his later testimony that it is a proprietary process and Google doesn't give that information to anyone. So the Commonwealth couldn't get it. The Commonwealth's the proponent of the evidence, not the defense.
Well, you would have been tied up in litigation for a long time with Google trying to get their proprietary information. But I guess what I'm trying to understand is, are you saying that, is your position that that this Google data, this GPS location data, can never be authenticated as a business record, or simply are we just saying that the certification here was inadequate?
I don't believe that it can be authenticated as a business record.
Ever.
Because that's correct, Justice Brobson, and that's because it's not a business record. One of the requirements of a business record is that the record be made by a person with knowledge or from information from a person with knowledge. Google location information is machine generated. It's not generated by a person. So it's that requirement of the business record exception cannot be met.
What if it's a person that has knowledge of the algorithm, has knowledge of the process, has knowledge of everything, because and they file the certification, and it says everything that we could possibly ever want it to say, discloses everything that you're asking it to disclose. You still say, as a matter of rule, anything that's machine generated, which is probably 80% of what we deal with in society today, can never be a self-authenticated business record.
I believe it can be self-authenticated under 902.13.
13.
I don't believe that it can be self-authenticated as a business record solely under 902.11, because 902.11 requires that the proponent of the evidence or that the certification establish the requirements of 8036, whereas if we, again, looking at the comment of 13, 902.13, there's a specific notation in the Commonwealth that when we're talking about a certification for purposes of 902.13, the proponent of the evidence does not need to prove the requirements of 8036.
So should we adopt should we, in this case, adopt a rule or announce a rule that says for machine-generated evidence can never be authenticated as a business record, you have to go through another self-authenticating exception? Would that be acceptable and, in your view, right?
It would be, and I believe that that's a fair interpretation of the rules as they exist when we look at the comment as well, the comments as well to 902.13.
Well, I had a follow-up question to Justice Brobson's. Do you think that our rules of evidence, as they stand now, are insufficient to address these evolving issues of modern technology?
I don't think that they're clear enough, I would say, as to how we deal with them. I don't think that they're clear enough in how they, in the extent to which they require reliability. And I think that's evident by the fact that the trial court and the Superior Court struggled, with and found that, well, the business record exception was met here.
Did anyone argue the applicability of 902.13?
No.
Well,
And
then-
we did argue, though,
I mean, I'm not suggesting that that's a fatal defect, but it's sort of difficult to fault the Superior Court for not dealing with something that wasn't brought to their attention.
certainly. We did argue, though, that the proper mechanism for authenticating it was through 901B9. And the reason why we did that is because there was no certification that complied with the requirements of 902.13. I mean, one of the reasons. And I believe that it probably should have been argued by the parties. It should have been at least mentioned. It wasn't mentioned by.
What was the Commonwealth Court's, where the Commonwealth's basis for offering the evidence? What rule were they relying on?
Business records exception.
Okay, so, but as the proponent of the evidence, it was their responsibility to put forward the argument, and they didn't put forward under 13.
That's correct.
So if we say it's not a business record, you win.
I believe so, yes.
Okay.
I mean, I guess, would you agree that time will tell whether or not this is sufficient to cover the situation? I can't believe it is not. This is drawn from the federal rules. I mean, this issue cannot be one of literal first impression.
Right.
The rule itself is really actually very clear in terms of authenticating these records that are developed through electronic processes.
I agree after having read over the rule and the comments a number of times. I think that maybe when we look at them, just the rule and not the comment, and maybe if they're not analyzed, there could be grounds for conclusion. But I do agree. When we look at them as a whole, they are clear. And in 902.13, especially the comment to 902.13, makes it clear that there's two different certifications required for a business record versus certification required to authenticate an electronic process.
Did you argue 902.13 in your appellate brief to this court?
No, we did not. We did mention, though, again, 901B9, and it's important to note that 902.13 is essentially requires the same thing as 901B9. It simply excuses the Commonwealth, and because the certification in this case didn't meet those requirements, they didn't have a certification that met the requirements of 902.13. They were left with needing to present a witness to testify to what 901B9 requires.
Well, I'm just, I guess, a little bit taken back that we have a argument presented today on 902.13 where it's not cited in your brief in any manner.
I agree. It should have been mentioned in the brief, at least.
Counsel, do I understand you to say that 8036A excludes machine-generated records?
That's how I understand it, Justice Dougherty.
Let's follow your theory. Let's jump to 902.13, which makes a record generated by an electronic process or system self-authenticating. If we follow your definition of 8036A, doesn't that necessarily invalidate 902.13?
I don't believe so, and I think, Justice Dougherty, that comes back to the comment of 902.13, where it specifically says a certification under this rule, i.e. 902.13, is not required to prove the requirements of 8036. So one of the requirements of 8036 is that it be a record made by a person or a person from a person with knowledge. We don't need to establish those requirements. The comment to Rule 902.13 tells us because it says so right in the comment. A certification under 902.13 doesn't require that, where it does require it under 902.11, which is, of course, for the business records exception. So that makes sense.
It doesn't, not only does it not require it, doesn't permit it. In other words, by
permit it.
satisfying 902.13, you're not satisfying 8036.
Correct. It says it's not required and it doesn't permit it. It says it right there in the comment, yes.
So, counsel, your position in your brief is they had to bring in a witness. their certificate was insufficient, they had to bring in a witness.
That's correct, yes.
So I asked you the question if they had complied with 90213.
Yes, that's how we started
That's how
down
we
that
got
road,
there.
yes.
But your position in this court is they had to bring in a witness.
Because the certification that they produced was insufficient under 90213, yes.
But they didn't try to get it under 90213.
Exactly.
That's, but why, I'm not going to hold them accountable for not satisfying 90213 when they didn't even try. They were trying to get it under the business records exception, and they either did or they didn't.
Correct, yes. That's correct. And the trial just let it in under the business record exception, and that's what it went up to in the Superior.
If they wanted to rely on 90213, it was the Commonwealth's burden to rely on it in the trial court. It was the Commonwealth's burden to present the evidence, not your burden to raise it as an alternative pathway.
I would agree with that, yes, Justice Probson.
All right, would you like to conclude?
Yes, thank you, Your Honor. So we would ask that the decision of the Superior Court be reversed and that the matter be remanded for a new trial.
Thank you.
Thank you, sir. Let's hear from the Commonwealth. Assistant District Attorney Jackson.
Good morning, Your Honors. Chief Justice Todd, Justices of the Supreme Court, may it please the Court, Adrienne Jappi from the Montgomery County District Attorney's Office. As you're aware, there's two issues before the Court in this revenge-induced contract killing. The first issue is whether the trial court properly admitted the Google GPS location data, and the second issue is whether Lieutenant Mitchell was properly permitted to testify as an expert regarding the Google location data. I would submit, I'm going to start first with the second claim. I would submit that that claim is waived. The defendant did not challenge Lieutenant Mitchell's qualifications following the voir dire. After voir dire, the trial court said, are there any objections? The other defense attorney said no objection, and Mr. Ricky Vance's attorney made no comment at all. So the court said the lieutenant is admitted as an expert. It wasn't until later on during the direct examination, maybe 10, 12, 15 pages into the direct examination, that when the prosecutor was showing or was moving for admission of Lieutenant Mitchell's reports, at that point, for the very first time on the record, is when Ricky Vance's attorney objected. He objected on the basis of hearsay and authentication. So I just want to make clear, that was the very first time it was objected to. We gave notice of the...
Counsel, as a result of that objection, did the trial court allow the admission of the testimony and the report?
I'm sorry, I didn't hear you.
As a result of that objection that defense counsel made at the time of its request for admission, did the trial court overrule the objection and allow it into the record?
Yes, Your Honor, he did overrule it, and it was introduced into the record. I do want to address a couple things that were raised by my opposing counsel. One of them is concerning the fact that he didn't, object or file any motions in limine at the time he got the notice. And I believe he stated that he wasn't aware that the lieutenant was going to be testifying as to this Google GPS location data. I would submit that that is completely contradicted by the record, because by the time the business record certifications were sent, the defense attorneys already had the expert reports of our witnesses, had two expert reports of Lieutenant Mitchell, both of which were inundated with GPS location data, and each report was approximately 300 or 400 pages, and each report mentioned GPS location data probably about 100 times. So defense counsel was well aware of that. Defense counsel was well aware of the certifications that were sent from Google. However, at no time were there any objections made. At no time were any attempts made to contact the person from Google whose name was in the certification. At no time were any attempts made to, I don't believe any attempts were made to get their own expert.
Well, regardless, if I could just interrupt on that, I mean, putting waiver arguments aside for a moment, the initial burden of authenticating is on the proponent, you. So,
Right.
How would you? I guess what I wanted to get to is, what would you offer the court by way of your take on the black box problem? In other words, neither Lieutenant Miller nor anybody else that was in the courtroom that day could explain to the fact finder what's inside Google's little black box. And this is a problem that courts, not just us, but courts are dealing with on these proprietary algorithms. What do you think? Do you think our current rules address this adequately, and what's your take on that?
Your Honors, the black box nature of some algorithms is in fact a legitimate concern, but it does not render all machine-generated evidence unreliable or inadmissible. The court's role is to ensure that the evidence is properly authenticated, and that was done in this case. We authenticated it under 902.11. We submitted the certification to opposing counsel, and I will say, even though it was done under 902.11, not 902.13, our certification was very specific, had not just what was required in 902, but it had the extra language that's required in, not just what was required in 902.11, but it had the extra language that is required in 902.13 that specifically says it produces accurate results. So that extra information was in there, and then it was followed by language, the accuracy of Google's electronic processes and systems is regularly verified by Google. So that extra
Counsel,
location...
let me take a step back to follow up, because let's put aside the lawyer's language for a second and get to the nuts and bolts of what Justice Weck's asking you. You said they didn't hire an expert.
Right.
If they had hired an expert, because we're not that's necessarily dealing with just this case, we have to promulgate a rule regarding authentication of this particular type of information moving forward. If I want to hire an expert, I mean, everything you're talking about in that certification is a certification by some Google engineer that it's operating within parameters, et cetera, et cetera, et cetera. But we all agree and we all know it's proprietary. If I wanted to hire an expert, how would the expert verify that information? Because notwithstanding what Justice Brobson asked you, we all know 80% of this is AI generated or 80% of this is kind of an algorithm. But algorithms don't operate with independent agency. They basically respond to human input. So a human engineer at some point, some software engineer, creates these particular programs, and that algorithm operates in accordance with the human input. So it's telling it what to do and how to react to the information that's in there. If I want to hire an expert, how do I test the accuracy and reliability of that information?
That's a good question, Your Honor.
Paid the big bucks.
Well, I'll say this. I think the rules themselves are sufficient for ensuring that the evidence we are seeking to produce, whether it's GPS records or regular cell phone information from cell phone carriers, I would submit that under the rules as they currently exist, there's enough safeguards in place to ensure that not only with the self-authentication, but with Rule 901 as well, I would submit that there's sufficient information in there to ensure the integrity of that information. Other than that, other than defense calling an expert and trying to...
Well, it ensures the integrity of the information. I think that's what authenticity is the information what everybody's purporting it to be. Justice McCaffrey's question goes to this idea, you're the proponent of the evidence.
Right.
And when I'm not thinking of this in a criminal context, I'm thinking these rules of evidence apply, in civil context as well. Why should the proponent of this evidence, this black box information, get a pass on proving that it's reliable? Why can they just put it in because it is what it is, or purports to be, and then force the defense side, either on the civil or the criminal side, to have to come in and now prove its unreliability? It seems to me that is backwards. The proponent of the evidence should be able to establish the reliability of the evidence. Not that it just is what it is, but that it's accurate, that it's reliable.
Well, I think the adversarial process allows both sides to probe the strengths and the weaknesses of these kinds of things.
No, but you got a pass. Yeah. You got an absolute pass. The way this authentication rule is working out now, and the way we're developing this jurisprudence on this machine-based evidence, is we're getting a proponent like you who wants a pass that says our current rules put all of the burden on the defense, criminal or civil, to essentially establish that what you have already put in front of the jury or what you have already put on the record is bunk. And why shouldn't you have to, just like you would have to do with a witness, shouldn't you have to put the evidence on first to say, no, this is not only what it purports to be, it's also reliable. It's also backed by science. It's also, there's an expert that comes in and says, yeah, I've looked at all of this and this is good data. Why shouldn't that be on you?
Well, it is on us, and we have the rules of authentication for a reason. We have 901, 902 for a reason that allows us to put this through with the certification, and then once we meet our requirement, then the burden shifts pursuant to 8036, the business record exceptions, it shifts to the defendant.
What about the certification?
As with all records.
Well, what about the certification? What is it about the certification process that deals with the black box problem? Why shouldn't you have to deal with the black box problem? Why should a defendant have to deal with it?
Well, we deal with it too. When we bring the evidence in, we question the witness that's coming in, and then the defendant can question our expert that we have to the extent that we do, in fact, have an expert. They can call the black box witness.
What did your expert say about the algorithm and how this data is calculated and how it's generated?
The rules don't require our expert to, the expert rules, Rule 702, 703, they do not require the experts to testify as to the proprietary algorithms that are involved in these.
How do we know it's accurate?
Well, I'll tell you how we know it's accurate in this case, because the Google location information, well, I'll tell you how it's accurate. We know it's accurate in this case and in everyday life, how we know it's accurate. Because millions and millions of people use GPS Google data. Uber drivers, that's their default. They use them. Obviously, when we call, I wouldn't imagine anyone here has plugged an address into Uber and gotten gotten sent or delivered to a wrong address. When you plug in Google Maps, I took Google Maps here, it got me here. My colleagues took Google Maps here, it got me here. Millions and millions of people. So it behooves Google to submit accurate data and to verify and to check their outputs on a regular basis. So that's just the millions of, for consumer protection reasons, or for consumer reasons. And then also in this case itself, the data was reliable because much of the data that was learned much of the information or the evidence that came in a trial that the detectives learned, that they learned through the defendant's significant other, and from cell phone, the cell tower information, it overlapped with or was corroborative with the GPS data here. Now, the GPS data had a smaller margin of error, just a few meters, but for instance, the day of the murder, the one defendant that was on trial and then the other defendant who we were unable to bring to trial, their cell phones sat in a car for 3 hours during the time of the murder. So they obviously did not, when they drove in the car to the homicide, they obviously did not bring their phones with them. Lieutenant Mitchell testified that the one defendant's 2 phones and the other defendant's phone, so a total of 3 phones, remained in the area of East Gorgeous Street and Clearview Drive. So he knew within a few meter radius that the phone stayed at that location. However, the defendant corroborated that. Our detective did not say the phones were in a car because he couldn't place them with that much specificity, but the defendant specifically told I don't recall if it was Lieutenant Mitchell or another detective, that his phone and the other person involved one of the other people involved in this, Marche, his 2 phones remained in the car that evening for that entire 3-hour period. And Ricky Vance, the defendant who is arguing here today, he said he left the phone in the car for those 3 hours and then went to go sell drugs. So the defendant himself corroborated what Lieutenant Mitchell ascertained from the Google data, the Google records, that the phones were at this location. Then the day after the murder, we had testimony from the defendant and his significant other, both of whom said that they went to Marche, one of the other men involved, went to his house the next day, purportedly to the defendant didn't say why he went there, but our theory was it was purportedly to discuss the homicide from the day before. So our Google records showed them going to the exact location, or the area showed Vance going to the area of Marche's house driving all the way up to Schuylkill. Well, that was corroborated not just through the tower records, which obviously did not corroborate it with as much specificity, but it was corroborated by the defendant and his significant other, both of whom testified that they went to Marche's house the next day. So it was corroborated during the trial itself by abundant other evidence.
So let's assume that any error in letting the Google certification in and the records that were attached to it was harmless error, just based upon everything else that you described, placing the defendant and others in the particular locations. Can I just ask you to go back to really the predicate issue here? And tell me what you think 901B9 means when it says evidence must be offered describing a process or system and showing that it produces an accurate result.
901B9 is not applicable here because the evidence was admitted under 902. 901 only comes into play when something is
Let's assume for the
not...
sake of argument, we say it was error to allow that evidence in as a business record. And we're trying to get to really a much larger question here with this case. So I'm asking you for your opinion as to what 901B9 would require if you wanted to get into evidence the Google mapping information.
Okay, so that would come into play only if the defendant can establish that we made no credible showing that the challenge data lacks or trustworthiness.
Wait, how do you get there? This is the proponent of the evidence's burden.
Right,
You
then
are
we
the
would bring in...
proponent of the evidence.
We would bring in extrinsic evidence, whether it, I don't know if it would be
Would
someone...
it be a witness?
You're talking specifically about the Google evidence, how we
Yes,
would get that in?
only the Google
We would likely get someone from Google to come in if we had to go that route. But in this,
Describe the process or the system. Correct? I mean, I'm reading directly from 901B9, which to me deals with the subject matter that we're dealing with here, which is evidence about a process or system. And the rule is pretty clear as to what is necessary in order to authenticate that kind of process or system. So would you need to bring in someone or maybe more than one person from Google to describe the evidence, to describe the process or system, and to show that it produces an accurate result? I mean, this is just classic authentication, right? I mean, you're
right,
obviously
but
a very experienced good lawyer.
honestly, I know you don't want to hear this, but I don't think we get there because it's self-authenticate, and then also because
Can I
we
stop
have
you
other...
there? You do have, forget about your other evidence, but let's just talk about authenticating these Google records. You said you brought in a self-authenticating document, except that if you look at 902.13 and the comment to it, it specifically says you have to include in the certification that what would be necessary under 901B9. So that would mean the certification would have to describe the process or system, and it would have to show that that process or system produces an accurate report. You do that, give advance notice, that gives the defendant the opportunity to get an expert to say, this is bunk, this isn't accurate, this isn't how it works. But until the proponent puts forth this evidence, the defendant really doesn't have anything to work with.
Well, the defendant can work with the certification that we sent them and get their own.
No, assume for the sake of argument that your certification was not sufficient. Assume for the sake of this discussion that we might say that the appropriate certification in a case dealing with Google records or any process or system is 902.13. That's not how you proceeded. You proceeded under the business records rule, as opposed to the rule dealing with processes or systems.
Right, and as the rules currently exist, we were permitted pursuant to the rules, how they exist now, that was the correct method by which we were to proceed because we had the certification.
901B9 and 902.13 are currently existing rules.
Right, but you don't get to 901 if you have the certification. So that's why we never got to 901. We were at 902.
The certification is only a method to establish authenticity under 901. That's all that your certification could ever do, is establish authenticity. That's why you answered it.
Right.
Why did the Commonwealth choose the business record exceptions as opposed to 13? I mean, 13 seems to be clearly on point, which I think is what Justice Donahue is kind of getting to. It's
Yes.
definitely more specific than the general business record
And
exception.
I believe when the request was sent to Google, that's the reason they put the extra language in their certification, I would imagine, because they probably
Who's they?
Google when they
It.
What was that?
It. Google's an it.
Oh, it. I was referring to the
Or she.
gentleman that submitted the certification. But I would imagine when they got the request,
When they got what request? When it got what request?
When we sent them the search warrant for the record.
And Google the search warrant.
When we sent Google the search warrant, the common practice of the agencies or the entities to whom we send search warrants and they send us business records back, they do a certification. And I would imagine Google did the certification, added the extra language in there because they imagined they were doing a certification under 902.13.
Well, but, okay, so you didn't, when you sent the, so I'm a little, okay. So the process of you sending a search warrant, you're advanced thinking about how you're going to authenticate it. And you have asked whoever's receiving the search warrant to sign a certification?
I was not involved in the trial, so I shouldn't speak for the trial attorney and the lieutenant. However, I don't believe we specifically, I think Google, AT&T, Verizon, all these agencies know what to generally put in these certifications, so I can't answer if.
But I mean, would you agree generally with the point, though, again, I think Justice Donahue was raising, that the business exceptions, records exception is fairly general, whereas 13 is more specific to deal with machine-generated data, which is really what you're dealing with here.
Right, but there's only one extra component in subsection 13. It has the extra language about accuracy, and that was in the certification.
But somewhere at the trial, the Commonwealth made the conscious decision not to try to get this in under 13, and I'm trying to understand why.
I don't think it was a conscious decision. I think we are just used to getting records like call detail records and things of that nature under 902.11. I don't think it was a specific decision to forego going in under subsection 13 and instead go in under subsection 11. That's what I surmise.
Jackie, could I ask you what I asked your opposing counsel? Do you think our current rules of evidence are clear enough or sufficient to address the issues that we're seeing with modern technology?
I do, Your Honor. Well, particularly for this computer-generated GPS data, I would submit that our rules are in fact sufficient to provide enough safeguards for this type of data. Now, with evolving technologies such as AI, perhaps not with this case, but perhaps in the future, more safeguards might need to come into play. I know the federal rules, I think they're revamping Rule 707, and it went through the judiciary already. Now they're in the public comment phase, and I think in the end of February that will be done. So I'm curious to see what happens with that. But as it exists now, I guess perhaps a heightened scrutiny for AI complexities maybe in the future. Again, not for this case, because AI has things like hallucinations in there, and it's just not as tested as things like GPS, which I indicated that millions of people use it on a daily basis, millions of people rely on it on a daily basis, and it just differs fundamentally from generative AI.
Are you suggesting that as a result of that, the Google GPS information does not need to be authenticated because everybody relies on it?
Oh, no, I'm saying it needs to be authenticated, and that's why we did authenticate it in this case.
Well, let me go back to one thing you keep saying, that your certificate contained the extra language. Using the word, it is accurate, it is reliable, does not meet the certification requirement under 902.13. It says, describe the process and explain why it is accurate. It doesn't say that you could say it's reliable and accurate. It says, describe the process.
My reading of 902.13 does not say that.
Take a look at the note to 902.13.
I don't have the note in front of me.
Yeah.
I apologize. Well, the bottom line is we put it in under 902.11. The defense, to the extent the defense is claiming it should have been brought in under 902.13, I would submit any such claim is waived because it was not raised in the courts below. And I would submit our certification as we submitted it was sufficient under both 902.11 and 902.13.
I think we get it. Thank you very much, both of you, well argued. And I think what I'm hearing is two experienced lawyers volunteering to serve on our Rules of Evidence Committee. Thank you both very
Love
much.
to. Thank you.
Would you call the next case, Mr. Minner?
Alsyrawan versus Department of Human Services, representing Mr. Alsyrawan, Mary Rowe, representing the department, Ms. Aplt.
In this case, appellant is a nonverbal adult male who suffers from both physical and intellectual disabilities. Appellant's mother and sister are his primary caretakers, and since 2016, they have been compensated for their hours providing his care pursuant to a program provided by the Pennsylvania Department of Human Services, DHS. In September 2016, DHS established a new policy known as the 40-60 rule that limits the number of hours for which certain services may be compensated. Appellant subsequently sought a permanent exception to the 40-60 rule, citing in part his religious needs. DHS denied appellant's request. Ultimately, this denial was affirmed by the Bureau of Hearings and Appeals, the Secretary of DHS, and the Commonwealth Court. The Commonwealth Court rejected appellant's claims raised under the Free Exercise Clause of the U.S. Constitution and under Pennsylvania's Religious Freedom Protection Act. In this discretionary appeal, we must determine whether, in its analysis, the Commonwealth Court erroneously conflated appellant's claims when it rejected both on the grounds that DHS application of the 40-60 rule imposed no substantial burden on appellant's free exercise of religion. Please proceed. Good morning.
Good morning. May it please the court. My name is Mary Catherine Roper. I represent Muhammad Alsyrawan, who is here today, accompanied by his mother, Ikram Abari, and his sister, Salam Alsyrawan, and I am joined by my co-counsel, Pam Walls. As the Chief Justice noted, the court granted review on the question whether the Commonwealth Court improperly conflated the First Amendment free exercise analysis with the requirements of the Religious Freedom Protection Act. The answer to that question is very clearly yes. The Commonwealth Court not only applied an inappropriate substantive standard, that is the requirement of a substantial burden, but also then imposed the statute's evidentiary threshold, clear and convincing evidence, neither of which are burdens that this First Amendment claimant should bear. We ask the court to vacate the decision below and order the department to allow Muhammad an exception to the 40-60 family cap to the extent that the department cannot provide religiously appropriate services for Muhammad.
Counsel, can I just interrupt you? That last part of it is very interesting.
Yes,
To the extent the Commonwealth cannot provide.
absolutely.
Was there any evidence below that the Commonwealth cannot provide religiously compliant services reimbursed for the full 133 hours?
Yes. So to begin with, at the before the pandemic ensued, Muhammad was attending a day program for about 30 hours a week that did respect the family's religious observance rules. And so that was not time that the family was compensated for. The family was compensated for the time outside, so of the 133 hours of services to which he is entitled each week. The family was compensated for the rest of the time because there were not religiously appropriate services offered. We can talk about the ALJ, which seemed to think that they could themselves create some services for Muhammad. But to date, and I will say just as an update, the department has now identified some potentially acceptable day programs. That would be great, but that would only take care of 30 hours a week.
Well, I'm glad you led off with this statement, because my concern in this case was, first of all, you didn't challenge the findings of the fact by the ALJ, which are then binding on appeal. But putting that aside, my concern in this case is you were seeking much broader relief, which was simply you want the arrangement that your client currently has as the exception. But here you're asking for something much more narrow, which is all you want is for the Commonwealth to provide your client, with the services that comply with the 133 and your client's religious restrictions. And that's really what you're asking for.
That is correct. On this record, we don't believe that there's going to be 73 additional hours.
No, I get that, but I think it's an important distinction. For me, it's an important distinction, because if we would reverse the Commonwealth Court and we would say your client's religious tenets have to be respected.
That's what we're looking for.
Right. But that doesn't mean your client necessarily gets the arrangement that your client currently has. If the Commonwealth can provide other services that make up for the 133 hours and your client's mother and sister don't get that compensation, you're fine.
That's absolutely correct.
Could I follow up on that then? Because just to clarify, because it's the law we're interested in, but the facts here are challenging. You mentioned in just a few moments ago that the center is available, or the service provider outside the home is available, and that provides or is able to provide the religiously compliant care. In other words, I took you to mean that this daycare place or whatever it is adequate for the toileting and personal needs aspect of this case. And to the extent that's correct, how does that combine with the 40/60 not get you to the number of hours needed?
So let me start with the day program that Muhammad attended before the pandemic, which was then shut down during the pandemic and was not available for his use at the time of the fair hearing, did meet his religious needs in that there were male attendants who could give him one-on-one attention when he needed it. There was a bathroom arrangement that did not require someone to be in with him while he was performing intimate functions, which is part of the family's privacy prohibition. So yes, there was a program, and there may now be another one. At the time of the fair hearing, the evidence was that there was not.
Well, that gets me to a question. I thought we were operating on a presumption, or you were operating on a presumption, that the Commonwealth would not be able to fulfill this function.
We are operating on a presumption simply based on the history.
Right.
That the Commonwealth may be able to come up with for instance, a day program. That's 30 hours a week. That does not fill all of the hours of waiver services that Muhammad is currently not receiving.
So it does come down to, going a step beyond Justice Robson's question, it does come down to you're asking us to say we will make an allowance for the mother and sister because of the unlikelihood that the Commonwealth will be able to meet the need through the agency.
Yes, and that exception only extends as far as the Commonwealth is unable to provide services. So as we said, a day program is terrific. That's about 30 hours a week.
But that may or may not satisfy the need.
It may or may not, but let's presume it does.
Okay.
Because perhaps there are options available now that were not available at the time of the fair hearing. We're not looking for
You're not looking for permanent relief.
we're not looking for a declaration that the facts that existed at the time of the fair hearing will never change. When you are taking care of an adult with disabilities, that person's needs and programming are always being reassessed, and we're not suggesting that there would be some exception to that for Muhammad.
But you're asking us to address the question in both contingencies.
Yes.
Recognizing that it may
Yes,
be
I mean, so there could be a lot of reasons why these day programs would not be appropriate. Perhaps they wouldn't have appropriate dietary provisions. Perhaps they wouldn't have any male staff. Perhaps they would not have bathroom facilities that are going to allow for the kind of privacy that Muhammad's beliefs require. Or perhaps they will, right? And so what we are saying is that it is the department's job to propose services. When it proposes services, and you know, putting aside things like sending Muhammad out, wandering out into the world with a male attendant, that's never been proposed by the department. Or requiring his mother to leave the home for up to 73 hours a week, virtually, you know, all waking hours, so that a male attendant can be there and not provide intimate care. We don't think we think the record is clear that those things are not workable and respectful of the religious exercise. But to the extent there are services offered by the department that do meet those standards, the family's always free to decline services, but then the family doesn't get paid for the time that those services are available.
It seems like an eminently reasonable position that you're taking, and but it's sort of different than the way the case was teed up to us.
I apologize. I think that we did I was a little sloppy and didn't always phrase our requests the same way, but this is what we are looking for.
Because it seems like, it seems like that's something that you and the department should be able to sit down with, and I have a hard time believing that they think, if you were challenging the 40/60 rule as a unconstitutional premise in and of itself and seeking to strike it, I could understand why the Commonwealth would be here fighting vigorously. But if what you're saying is give us the 133 hours in complying with the 40-60 rule if you can, but if you can't, allow us to keep doing what we're doing until you can do that. That seems like an eminently reasonable thing that reasonable minds could come to agreement on.
We think so too, and the Commonwealth thought so, and there certainly were some discussions between the parties after the Commonwealth Court argument. I'll just say it's not resolved at this point.
Can I follow
But
up?
quite apart from that, right, we've got a published opinion from the Commonwealth Court that grossly misstates First Amendment jurisprudence.
Well, I wanted to follow up because you're here, aren't you, because the Commonwealth Court held that the record, I'm quoting here, the record evidence in the instant case similarly supports that mother's preference, rather than on a burden on the free exercise of religion, is the reason for the permanent exception request. It's why you're here, right?
No, Your Honor, the Commonwealth Court opinion said a lot of things, but the primary holding by the Commonwealth Court was that Muhammad had not established a substantial burden and therefore could not meet his a substantial burden on his religious exercise, and then therefore could not meet a threshold requirement of either the First Amendment or the Religious Freedom Protection Act. Ms. Albari has always said that she's seeking this exemption, and we are here seeking this exemption for religious reasons. At the fair hearing, counsel for the department said to her, do you have reasons other than religion for wishing to be the primary caregiver for your son? And she said, yes, I have lots of reasons why I think, as I think any mother would, that she and her family provide the very best care that Muhammad can have. She was explicitly asked, do you have reasons besides your religion why you prefer to provide his care? Of course she does. She's his mother. But that's not the basis on which
It's your arguments that it's the wrong threshold burden. The threshold burden imposed on you was wrong.
Correct.
And let me ask you, if we agree with that, why should we reach the merits rather than remand it for application of the correct threshold?
Because, Your Honor, the test under Smith is essentially a legal one that is uncontested, right?
What's left of Smith? That aspect of Smith that's still surviving.
Smith still survives, and in fact, in June, the Supreme Court issued another free exercise opinion.
Carson.
Actually, I was thinking Mahmoud. In June of 2025, the Supreme Court issued a new free exercise decision in which it said, we don't need to grapple with the Smith question of whether the rule in that case was generally applicable, because we are going to look to an older case, Wisconsin versus Yoder, and the concept of interfering with a child's religious upbringing as the basis. And so Justice Alito, writing that case, simply said, we didn't say Smith is gone. It didn't, and in fact, in 2021 in Fulton, Smith was in full force, right? That was Fulton versus Pennsylvania was absolutely a Smith decision. So at the moment, the Smith rule, and the Smith rule is, first of all, it's a safe harbor, right, for government policies that are, in fact, both neutral and generally applicable. But when the policy is not generally applicable, it falls out of the safe harbor, and then the refusal to grant an exception must be justified by strict scrutiny.
How is this not generally applicable?
The primary reason, and we will list several in our briefs, the primary reason why the 60-40 rule is not generally applicable is that there is a mechanism for individualized exceptions. The Supreme Court makes clear in Smith, as well as in Fulton, that when a government policy creates a path for individualized exceptions, as I'll explain the history of the procedural history of this case in a moment, that opens the door to picking winners and losers, right? And discriminating on the basis of religion. And that is why, when there is this individualized discretionary decision about exceptions, the denial of an exception on the basis of religion must be justified by strict scrutiny. So,
I'm sorry, finish your sentence.
so the primary evidence that there is a system for seeking exemptions is the history in this case as well as in the Jalil case. When Ms. Albari first filed her initial request for an exemption, the department rejected that on the grounds that it had no power to give a permanent exception to the 60/40 rule. That got appealed up through the administrative process. It got to the Commonwealth Court, at which point it was remanded for a hearing on the merits of the question of the exception. The department agreed that it could and would consider the merits of Mohammed's request for an exception to the 60/40 rule. That is exactly what happened in the Jalil case. As the Jalil case makes reference, there are two recipients in the Jalil family. One of them had been granted an exception, but in the decision that came from the Commonwealth Court, the other sibling was not granted an exception, but was given the same, honestly followed exactly the same path. Initially denied out of hand, but later given an opportunity to look at the merits of the question for the exception, and ultimately that request for exemption was denied on the merits of the request, not because there isn't a path. There is a path. There is a mechanism.
Are you telling the court that there has been a permanent exception granted?
There has been a permanent exception granted, and that has been stipulated by the department. That stipulation is found on page 182 of the record. But quite
Is that the Jalil case?
It is not. So the Jalil case, in which you have seen a decision, was the denial of an exception to the other sibling.
Okay.
The first sibling, there is no litigation because an exception was granted. The second sibling was denied an exception in Jalil. And that is what is stipulated by the department. But quite apart from whether there has been an exception, the Supreme Court of the United States in Fulton versus Philadelphia is very clear that, and the same words appear in Smith, that where there is a mechanism for individualized exceptions, that trigger that, but one is denied when an exception is sought.
I think it makes your argument a little harder if there's never been evidence of the department using the discretion to give out a permanent exception.
But in fact, it has. So not only does it have a path for discretionary exceptions, it's exercised that discretion in the
But
past.
the path is a little bit different. I mean, I agree that the department has granted exceptions primarily as a result of litigation. It seems like it's more of like a settlement kind of a thing or something like that. And I'm not sure what you mean by permanent exemption and how that jives with what you said beginning about this sort of being a temporary fix. But my question is, Fulton, the policy, the written policy that was being challenged, the written policy had an exception mechanism in it. And I think that's what the Supreme Court was looking for, is if you have a rule with an exception, then you don't have a rule. And here, I don't think the 4060 rule as it's written or as it stands includes any exception mechanism. This is something that was court created or agency created, and maybe it was wrong. Maybe, is the 46 rule in a regulation?
It is a regulation. It is a state regulation.
Okay, so it's an actual it's not a statement of policy, it's a regulation?
It's a regulation. It's also written into the waiver, that the state writes the waiver.
The state plan, okay. So it's something the agency must comply with? It's a binding norm?
It's a binding rule within the agency. However...
Well, but just before you do the however part, there's nothing in that binding rule or that binding norm that says, and the department can grant an exemption.
No, Your Honor, but I will say that in all of the history of First Amendment jurisprudence, I never make these kinds of blanket statements, but I will say to the extent that the government violates the First Amendment in practice, but not de jure, does not get them off the hook.
No, I'm just trying to create the difference between Fulton and here. Fulton, the policy had an exception written into it. This one, the exception was post hoc.
So-
It was post hoc created. I'm not saying it doesn't break the dam and the water doesn't flow. I'm just saying that it was a post hoc exception grant, not in the rule itself.
So to be clear, I believe that the exception in Fulton was not written into the non-discrimination provision that was the basis of the city's denial of the exception to Catholic Social Services. It was an exception sort of more broadly that applied within the program. And so I don't think that distinction, and that is certainly not something that Smith says. I don't think it's something that Fulton says. They talk about a mechanism. If there is a mechanism, if there is a system.
And this mechanism is sort of an unwritten mechanism that came about as a result of individualized cases. It's not published anywhere. Nobody but a great lawyer like you who has followed these cases so closely would even know that there's an ability to seek some sort of an exception.
Well, so I think anyone who practices with the department knows. I just want to answer one question you had, which why are we calling this a permanent exception?
Right.
And the reason is that the regulations actually do have a set of temporary exceptions for up to 90 days for various kinds of emergencies about personnel not being available. And we are calling this a permanent exception to distinguish it from that de jure exception regime, which is not what we're dealing with here. There is a de facto exception regime that is followed by the department. The department, Commonwealth Court, department stipulated to the remand of these cases to be considered on the merits and then held merits hearings, right? That the system for seeking an exemption, I'm hoping the next person doesn't have to go all the way to the Commonwealth Court to get their fair hearing on the merits of their request for an exemption.
But the hearing, assuming you prevail, the hearing, if we side with you, would look more like you have not provided us the 133 hours or however many approved hours that we're entitled to in compliance with our religious restrictions. Therefore, you must allow us to provide it this way until you can accommodate us some other way.
And that was the argument being made by Mohammed's counsel at the hearing. The ALJ, I think, is not really empowered to grapple with constitutional questions, but the question was raised there and at every stage, right? And that question is finally grappled with in the Commonwealth Court, whose grant of review over agency decisions includes determining whether they comply with constitutional rules.
Okay, Ms. Roper, I think we get it. Could we hear from your opposing counsel, Ms. Howlett?
Thank you, Your Honor. May it please the Court, my name is Camille Howlett, and I represent the Department of Human Services. I'm also accompanied.
Get a little closer to the mic.
Sorry.
That's all right.
I'm also accompanied by my co-counsel, Helene Locks of the Department of Human Services. And as appellant stated, the only question at issue here today is whether the Commonwealth Court conflated its First Amendment free exercise analysis with its disposition of appellant's Pennsylvania Religious Freedom Protection Act claims, and the answer to that question is no. There's ample support to hold that the Commonwealth Court properly analyzed the First Amendment issue by first considering as a threshold matter whether a substantial burden was present within its First Amendment analysis. The U.S. Supreme Court in Hernandez held that the free exercise inquiry asks whether the government has placed a substantial burden on the observation of a central religious belief, and if so, whether a compelling governmental interest justifies that burden. This language shows that the requirement for a substantial burden is a threshold matter. And this court in Commonwealth v. Stewart recognized that a plaintiff has the initial burden of establishing a substantial burden on his or her free exercise of religion.
Is that still the proper threshold, given the post-Smith free exercise cases?
Our position would be yes, and that's based on, even as recently as 2021, the Superior Court and the Third Circuit have reached similar holdings. Smith, I think, has been superseded by statute, and although it addresses the compelling interest test, it does not address the burden required. And this court in 1997, which was post-Smith, reached that holding regarding that the plaintiff has the initial burden of establishing the substantial burden. The Superior Court and Third Circuit have also reached similar holdings as recently as 2021.
What about Ms. Roper's argument that the fact that your client has set up this exception regime changes the game, so to speak, that the availability of discretion displaces the paradigm that would exist were there not such an exception regime?
So that goes to the general applicability, which as an initial matter, I do think goes beyond the limited aliquotter granted here. But notwithstanding, our position is that the rule is generally applicable. Although there was one exception granted, as mentioned in Jalil, the record does not contain the reason for that exception. The Secretary's order granting that exception did not provide an explanation, so that information is not on the record here.
Well, that's terrible adjudicating, if you issue an adjudication without findings of fact and conclusions of law.
Agreed.
Right? But the fact is there are exceptions, granted. The fact is there is a mechanism, at least for maybe not published mechanism, but a well-known mechanism for seeking religious exceptions. You have to agree with that, right?
Yes, I would not dispute that an exception was granted, whether it was religious-based.
Not only is an exception granted, exceptions are entertained. People can file applications for exemptions, and the Secretary will address them.
Correct, but I would argue based on Spivak, which was a Third Circuit case, that different categories of an exception can be allowed without rendering a rule not generally applicable. I would also argue that under Jalil, where the exception was at issue, and then the sibling also requested an exception, the court did not find that dispositive and did not grant an exception to the sibling. So whether the exception is needed is what the substantial burden looks to.
Could I ask you, it baffles me a little bit why we're here, why you're here before the Supreme Court on a question that seems to be relatively straightforward and from my perspective at this point, not speaking for my colleagues, seems to be a reasonable request for an exception or an exemption. Why are we here? Why could this not have just been resolved?
Sure, so there were efforts to and the department has offered services that it contends could meet the religious needs of
To
appellants.
some extent, but then at other times it can't, right?
Well, I would argue there are services available, including and especially life sharing. When families want to exceed the 40-60 rule, ODP steers them towards the life sharing service, which is a mechanism whereby individuals receive a stipend for providing services under a contract with a provider, and then the 40-60 rule is not applicable in that situation. So I also think the nature, we were under the impression it was seeking a permanent exception, and I think there have been meetings and work with the family. ODP practices person-centered planning, so ODP does not dictate you have to take this service. It can offer a service that's available. The appellant and
Let me ask you, you just indicated that the ODP would get a provider. Now, is there a provider contracted with your organization that can cater to the strict religious needs of the client?
So ODP, I personally, I don't know. I know there has been work with the ISP team, the individual support plan team.
Which brings me, interestingly, because the Chief Justice just asked you a very simple question, and your response is based upon an unknown or an uncertainty. Your argument is that we denied it because there's an exception when we could get money for a provider, but we don't even know if there exists a provider that cater to the religious exceptions or the religious responsibilities. So how can you stand up here and say we object based upon a lack of information? Because that's what you just said to us.
Sure, and let me clarify. care is available, especially through that life-sharing service. That model was offered to the family and it was rejected because some of the, I think just the payment situation was not what the family wanted. So that underlies ODP.
Well, it's a lesser payment arrangement than what they would get if you granted the exception.
Correct, but our position would be that a financial burden does not amount to a substantial burden on his religious exercise.
I mean, I understand that argument, and I've seen that in the briefing. The question I have that it brings to mind for me is whether that argument holds water after Carson versus Macon. Because I think the argument you've just made was challenged, at least, if not fatally undermined, by what SCOTUS did in Carson versus Macon.
I would have to familiarize myself better with the case.
That's the main case.
Yeah, I think based on what was found by the Commonwealth Court, that it was the mother's preference and that any financial burden does not rise to a religious substantial burden. His waiver services are provided for the benefit of the individual, not the financial benefit of the family, that it would not be a substantial burden on his religious exercise, and there is care available through other programs that can meet his religious needs. As they stated, he's been in a day program where he's served by male and female staff. He's able to be served by an unrelated male without impeding his religious beliefs. So there are options available. Because ODP practices person-centered planning, there's a care team that looks at providers and available options and presents that to Mr. Alsyrawan, and he is able to deny services if he's not happy.
That's what makes these cases so difficult, is it's very fluid. These are very fluid circumstances, and by the time they get to us, the facts on the ground have changed.
Yes.
If we were to issue tell me if this somehow offends the Commonwealth. If we were to issue just a ruling or rule that, the Commonwealth has to provide a path to 133 hours of services, if they want to enforce the 40-60 rule, that does not offend the family's Muslim faith. Do you have a problem with that principle?
I think as long as it can be done in accordance with enforcing the 40-60 rule.
Yeah, well, no, but that would be your burden. Your burden would have to be to provide them a path. If you're going to enforce this 40-60 rule, and you're going to say it's generally applicable, which means it applies to everybody, you need to create a path to getting the 133 hours of approved services that both honors the 40-60 rule and their religious restrictions. And if we said that, would you have a problem with that?
No, and I think that path is available through life.
We have to kind of ignore that because, again, the facts on the ground have changed since when was the adjudication here?
Let me check.
Like years ago, right?
The BHA adjudication?
Yeah.
Yes.
Yeah, so the facts on the ground have substantially changed. But if we were just to say that simple proposition, which seems to me to be, I haven't formulated my final thoughts on this, but it seems to be like a principle that almost everybody would universally agree with. Wouldn't the Commonwealth agree with that?
Yes, there's no contention that his needs, the hours are not needed to meet his needs. I think the issue comes down to how the services are arranged to meet those needs.
Right, and that could be sorted out when you provide your care plan. If they don't like it, then you go to the BHA, you have a hearing, an adjudicator says whether the plan complies with the religious beliefs in the 40-60 rule, all that fun stuff, and then it'll be a plan-specific issue. But here, the facts have changed. And you don't disagree with the law, or you don't disagree with your responsibility. We may have some quibbling about the Commonwealth Court's analysis, but at the end of the day, everybody seems to agree on the principle.
I would agree, yes. And if there is a change in facts, I think it would be something that would need to be raised again through a factual hearing, because the record being what it is, we're kind of...
Yeah, counsel, this is not on you because you were assigned the job of arguing this case before us, and you've done a very nice job. But, the department would be well advised to try to resolve these kinds of matters in a reasonable way before they get to the Commonwealth Court and the Supreme Court.
I take that, and I do think there have been efforts. They just unfortunately weren't successful here. I think efforts are ongoing even up to today. But
is this your first argument before our court?
It is.
Well, welcome.
Oh,
You did a
thank
very
you.
nice job. Thank you. We understand your position, and this was well argued on both sides. Thank you.
Thanks for bringing us a First Amendment case. We don't get
Fun
enough of
one.
them. Come to us more instead of federal court. We want this stuff.
Mr. Minner, we're going to take a 10-minute break. Would you call the case, Mr. Minner?
Federated Insurance Company versus Summit Pharmacy, representing Pharmacy, Mr. Siegel, representing
In this appeal, we examine a provision of the Workers' Compensation Act which sets forth the standard for determining prescription drug prices for purposes of resolving fee disputes between workers' compensation insurance carriers and the pharmacies who fill the prescriptions for injured workers. The statute provides that reimbursement for drugs shall be limited to 110% of the average wholesale price of the product. In conducting its statutory analysis, the Commonwealth Court afforded the term average wholesale price its plain meaning, that is, an industry average of the drug's wholesale price, as opposed to the Red Book price, index value, which the court found represented an inflated price set by the drug manufacturer. Accordingly, the court barred the Bureau of Workers' Compensation Fee Review Hearing Office from applying the Red Book pricing index when resolving drug fee disputes, finding that such fee schedule did not reflect average wholesale prices of pharmaceuticals. The Commonwealth Court further directed the Bureau to identify and publish a nationally recognized schedule of average wholesale price, which comports with the plain meaning of that term. Finally, the court remanded the matter to the fee hearing officer to apply the new drug pricing index to the instant fee dispute. We granted allowance of appeal to examine whether the Commonwealth Court erred in construing the governing provision and exceeded its authority by invalidating the Bureau's long-held designation of the Red Book Drug Pricing Index as the standard for pharmaceutical fee disputes. Please proceed.
Thank you. May it please the court, Daniel Siegel on behalf of the Summit Insurance Company, my co-counsel, Krista High. We're here today on essentially one issue in terms of the fee dispute, the fee review, which is, did the Commonwealth Court err by describing, and in this case, and contrary to Judge Saylor's opinion in the Supreme Court in TAP, when he wrote that it was an industry benchmark known as AWP in government formulas, the AWP average wholesale price, which had acquired a peculiar and appropriate meaning under Pennsylvania law. The Commonwealth Court invalidated that improperly, and in doing so, invalidated without saying so other statutes in Pennsylvania. Also, in invalidating it, it took a position that is contrary not only to what the AWP has meant and continues to mean as a very specific term of art in pharmaceutical pricing, and also contrary to the fact that 32 other states use AWP as the benchmark for pricing of drugs, 17 of which, like Pennsylvania, are AWP plus a certain amount. The advantage, and you have to understand that the AWP is an industry term to use, so if you try to use the regular term average wholesale price, no one, Commonwealth Court, the insurance company, no one has been able yet to really define that term. And
So that AWP is not really average wholesale?
no, AWP represents a term and has always represented a term in the pharmaceutical industry that essentially means it's the list price, it's the drug price set by the manufacturer.
Well, let me ask you, I think that's a straightforward argument and a compelling one, I think, but isn't this Red Book thing a PROTS problem?
No.
I mean, Truven Analytics could change these numbers tomorrow and the next day and the day after that, how can the law be hostage to what some outfit named Truven Analytics says the number is?
It's not a problem because PROTS, we designated the impairment ratings to a company, to the AMA, and essentially you had to use their guidelines. In this case, and in pharmaceuticals, all that is done is it sets a maximum price. So the maximum price that can be used is 100% of the AWP. It does not mean, and has never meant, that the provider, in this case Summit Pharmacy, has to use that price. So, and this is the perfect example, because Summit Pharmacy billed at 100% of AWP, not any other number, so it's not required. In PROTS, there was no flexibility for a physician. The physician had to rule exactly the way, it had to read the AMA guides, and it had to render a decision consistent with that. This merely sets, consistent with other cost containment regulations, a maximum. So it's not designating what the price is, it's designating a cap so that beyond that number, no one should be accepting reimbursement of funds. But a pharmacy is free to have any number it wants to do. And
isn't the cap, to Justice Weck's point, isn't the cap a policy decision that the General Assembly should make?
It is. And in fact, in doing so, they designate the AWP as in the statute, but it's not the PROTS decision type of problem, because it's not designating the actual number.
But the problem isn't with AWP as such. I mean, I think you have a strong argument there. The problem is how is the AWP selected? And the Bureau tells us, quoting them, quote, gives notice that it utilizes the Red Book published by Truven Health Analytics to determine the average wholesale price of prescription drugs. So I'm not sure how your response to either me or Justice Brobson resolves that problem. Because the Bureau puts the state's imprimatur on, the gold standard is Truven Health Analytics, whoever they are. Mm-hmm. Why is that any different than a government body saying whatever the AMA says, or whatever the National Association of Car Dealers says?
It's different because, one, it's only used when there is in a fee dispute. So in other words, if there is no dispute between the provider and the insurer, it never even gets to that. They could charge whatever number they want. When there is a dispute that goes to a fee review hearing officer, then and only then do they have a cap on what they can charge. So it's different, and it's not designating. Plus, in this case, every year, the Bureau is free to render any guide it wants. You're free to lobby on it. And in fact, that's part of the problem and why we don't even believe this case is properly before this court, because that is a discretionary act. And when determining whether an agency whether an agency declaration like that decision, a discretionary decision, the only appealable issues are when the agency either acts in bad faith, fraudulently, capriciously, or abused its power. There's no allegation of that here. And as a practical matter, in this case, these fee reviews that are appealed here were over many years. And each year, the agency, the Bureau of Workers' Compensation, issues its standard of which book is going to be used. And when it does, that's the standard. So we don't even know which year or whatever, even though the Bureau has used the Red Book as the standard for many years and without complaint.
But it didn't have to, but it doesn't have to. Their regulations make clear that they could use any national schedule.
Right. That's correct. That's absolutely correct.
So how do you then derive from that general authority that they have some notion that there is a term of art that's been developed? I mean, they certainly don't recognize it as such.
Well, you use the history of AWP.
Yeah, but I mean, your history is they've always used it.
They've used the Red Book, correct?
Okay, but how does that make it a term of art? That makes it the discretion of the Commonwealth for a number of years.
No, it's, I think we're parsing words.
Well, that's what we do.
Yes, I know.
Much as I hate it, but
Yes, but the Bureau is free to choose any of the standards that recognize the wholesale price, and it says in the regulation, it's a national standard that they use, so they can choose others. That doesn't mean there's one. They happen to have always chosen the Red Book.
Correct. That's why it works against the notion that it's a term of art.
Well, except that you have to, that doesn't take in the historical context of it. Medicare, Medicaid have used AWP, and again, it's the same term of art.
But many pharmacies don't rely on the Red Book.
Correct.
I mean, the major pharmacies aren't here. They didn't intervene. That nobody has an interest in this. I mean, because they, as every pharmacy is entitled to do, can negotiate for the price.
That's also in the regulations. It's another reason why PROTS wouldn't apply, because any pharmacy...
My question is just different. I mean, why is it that the Red Book is a term of art? I mean, the largest pharmacies don't rely on it at all. Many pharmacies just negotiate the price. Why isn't it just, it says what it means?
Because no,
Average wholesale price.
because no, if you try, and I'll, I could ask you, but you can ask anyone. If you say average wholesale price, no one has been able to give that as they've tried. It's plain language meaning. Is that the average wholesale price of the drug as dispensed? Is it the average wholesale price over a period of time?
Well, there was an alternative suggested to the Red Book in the court below.
They didn't offer an alternative. They merely directed the Bureau of Workers' Comp to come up with another.
How about the NADAC, which is compiled by the Center for Medicare and Medicaid Services? That sounds like a legitimate basis for average wholesale price for a government service.
Except that, one, the NADAC, as it's called, one, is not an average wholesale price. It's an average acquisition cost, which is different from an average.
Well, what is a wholesale price? Isn't that the price at which something can be acquired?
If you're using the term as it's used in the vernacular, if you're using it as a term of art, no, because it becomes, what does the industry...
Where does this term of art come from? I mean, that's what I keep groping for.
An artist?
An artist, yes, thank you. I thought about that.
Where it came from...
I did think of that. But I thought it was trite to mention it to this fine council.
It's developed, but it started in the 1960s when it was used by, much more widely used than it is now. But even from the 60s, when Medicare and Medicaid were accepting the average wholesale price, in every case, they were using these standards, the Red Book. There are other standards. There's really three main compendiums.
The Red Book doesn't even pretend to come up with a average wholesale price.
If you take the term as it's used in the common language, no. But if you take the term as it is used, and for example, below, both witnesses, even though the employer or the insurance witness was not accepted as credible, both acknowledged that is a term of art in the pharmaceutical industry. And when it's a term of art, then you have under Section 1903A, you have the language that says when words are construed according to their common and approved usage, but technical words and phrases and such others have acquired a peculiar and appropriate meaning or are defined in this part, which it's not, so a peculiar and appropriate meaning, that's where The AWP has always done that. That's why.
No, that's what the Red Book has always done. The Red Book has taken on a meaning, but that doesn't mean that average wholesale price has taken on an meaning in the industry or trade. Getting back to my point, many pharmacies, the largest of them, do not rely on the Red Book.
Many pharmacies don't use it, and it also depends on what type of pricing. So every industry has different pricing and different standards, so you wind up with a whole variety of different things. But you need, in workers' comp, for example, to have a standard for the cap that would allow, one, a price of every drug. So every drug, every generic drug, even if you buy generic Tylenol, every generic Tylenol has a different manufacturer number depending on who's manufacturing. So you have to have an across-the-board standard compendium that has all of those. There's very few that do. Red Book does, Medispan does. Those type of entities have that type of compendium. So you have that. You also have to have it because in
Counsel,
workers...
can I just, maybe you could correct me if I'm wrong, but both experts essentially testified that the Red Book price builds in a profit margin.
It does.
Well, why is that an average wholesale price?
That because...
See, that to me is just totally inconsistent with the concept of the acquisition cost.
But that's part of the difference and part of the parsing of the language here. The legislature, and this is really ultimately a legislative decision, not one for this court or the Commonwealth Court to be redefining that language, because that's the AWP is in the legislation.
Not Red Book. Red Book is not in the legislation. No. It says average wholesale price. And didn't the legislature build in a profit margin of 10%, AWP plus 10%?
Yes, but they built it in to the average wholesale price, which is a term of art. And if
Mr. Siegel, I think you have to answer Justice Donahue's very good questions, you have to acknowledge the history of AWP, which is when AWP was inserted into these statutes, both in the Workers' Comp Act and in the medical assistance statutes, AWP actually was AWP. Well, average wholesale price was considered the reasonable metric for purposes of capping under medical assistance as well as workers' comp, correct?
Yes.
And over decades, litigation has ensued across the country challenging AWP because essentially pharmacy companies were reporting jacked up prices that no longer resembled AWP.
At
right?
times, some were, yes.
Yeah, so where we are now is when the General Assembly passed the statute and added AWP, AWP actually was a term of art and actually meant average wholesale price. But over time, that's become not clear, which is why medical assistance statutes have changed all over the country to move away from AWP.
But the yeah.
Well, that's true, right?
Yes, correct.
Okay, so in fact, CMS has created NADEC expressly to move away from AWP and have said we are no longer using AWP, we're using something else, we're using NADEC.
But the legislature in Pennsylvania hasn't said that.
I agree. That's your answer. That's your answer. You have to acknowledge the uncomfortable truth that AWP doesn't capture wholesale prices anymore because it was an industry-driven metric that basically the industry abused. And while medical assistance statutes have been amended to account for that, the General Assembly has not touched this statute.
No, and in fact, since the original 110% of AWP statute, the legislature has on multiple occasions amended those provisions and still has not chosen to act and to amend the AWP. And as this court acknowledges, it's not its role for it to substitute its own opinions and for those of the legislature. Whether I agree or you agree, the legislature's had an opportunity. We showed you one example in our brief where they wanted to change it and it wasn't approved.
They've done it for medical assistance, they just haven't done it for workers' comp.
Right, and they could. They could easily tomorrow amend the statute. But
Then, of course,
instead,
that brings up Justice Wex-Prott's problem. Because what's happened, instead of the legislature doing anything to amend the statutes, the regs have taken over and said, well, here's what it is. It's the Red Book.
No.
And it's always the Red Book. Because you're saying it always has to be the Red Book.
No.
Because it was. And so it always must be.
no, the regs only say they have to designate a national standard.
Correct. And
The
they put
Bureau,
in the bulletin for decades, they've said Red Book.
Right.
And you're saying it has to be Red Book.
no, I'm saying it has to be one of the standards that does AWP. It could be Medispan, it could be the Red Book, there's one other, I can't, the name, I'm just looking for it, but there are three, Medispan, First Data, and the Red Book. Those are the three that are comprehensive databases that cover every NDC, that provide an average wholesale price, whatever that means.
Well, we know what it means from the TAP case from 2014.
Yeah, except that the TAP case was reversed on appeal to this court,
Well,
and
I mean, Chief Justice Saylor's opinion, then Justice Saylor's
yeah,
opinion.
and he right in the first opening paragraph said that it's known as AWP is a benchmark in government reimbursement formulas, and you know that's the language this court adopted. It's correct. It is a benchmark. It may not be one that you would pick or I would pick or but until the legislature acts, for this court to legislate on it would be just that. It would be acting as a super legislature. And in the Keystone Pharmacy case a year or 2 years ago, my case, you refused to accept when the Commonwealth Court legislated a new process for intervening in fee reviews. And you said, we can't do it because we would be substituting our position. That's correct. And in fact, we never even advocated for that narrow part of it. We advocated for the rest of the decision because we agreed. And this court, the Commonwealth Court, whatever they think of the AWP, it's partly driven. We all know that pharmaceuticals are expensive.
No, look, again, I think you have to concede there's decades of litigation. AWP has become incredibly unreliable, is not a price point that government can sustain to pay for benefits, which is why CMS has said we're no longer using AWP, we're moving to something else. Right. Don't try to make AWP look like this great thing. It's not.
Well, I'm not saying it's whatever you want to call it, a great thing, but it's the standard the legislature has.
That's your argument. That's your best argument.
It is.
Don't try to. I'm just suggesting to you respectfully. Don't try to defend it. It's not. It's kind of hard to defend at this point in time.
Well, the General Assembly can do a lot of things that aren't great. It's just
Right.
That's just what the law is.
Yeah. And until they change it, and it's used in many states in workers' comp benefit programs. In fact, after all the briefing was in, Optum put out a guide this year which showed all the different states what they were doing, and it showed 33 states have continued to use AWP as their standard for reimbursement because it covers so many medications. It covers the gamut.
Well, it's also like it's a lubricant for the machinery because it allows profit. It builds in profit. Right?
Well, yeah, and there, it does, because if you look at some of the low cost or some of the common drugs, for example, acetaminophen, Tylenol, the AWP for 90 Tylenol is $3.48. That plus 110% is supposed to be what the pharmacy gets, including the profit. The most expensive of the 19 most common drugs prescribed for workers' comp claimants in Pennsylvania is gabapentin. That's a 300 milligram tablet 3 times a day, a 1-month supply, 90 pills. They get $83 as the AWP and $8.30. Yes, there are times when the AWP is higher and the profits are higher. That happens. It happens in some of the prescriptions in this case. But that doesn't mean that you should be sitting here as a super legislature. That's the difficult part. And again, going back to it, it's the announcement every year, and you did ask the parties to address whether it was appealable. And I think that's important that we do, which is, yes, it may have been, if you don't accept, and I believe you should, it's a discretionary matter of a state agency every year. And those pronouncements are not reviewable by courts unless there's fraud or other actions. There's no allegation of that here.
What issue are you saying is only reviewable for fraud or other action?
The discretionary acts of a legislative body. Not a legislative body, I'm sorry.
What discretionary act are you saying is not before us?
The annual pronouncement of the price of the standard.
You mean the annual adoption of the Red Book?
Red Book or...
Well, under tire jockey, that would be challenged as a reasonable regulation.
Excuse me, I didn't...
Under tire jockey, that's a regulation, and it could be challengeable as unreasonable.
I'm not familiar with that case, but it's not an act where there's any allegation of any impropriety or anything like that.
No, but there's two issues in front of us, right? One is the Red Book issue, which I think is a tire jockey issue, but I'm not sure they preserved it. But the second issue is, what does AWP mean in the statute, which is not an issue of discretion, it's an issue of law that we decide on our own.
Yes. Aye.
Any other questions? Mr. Siegel, you may have done this and I didn't hear you, but did you introduce your co-counsel to the court?
Yes, Krista High.
Could you do it again?
Krista High.
Thank you.
Yes.
All right.
Thank you.
Thanks. Let's hear from Mr. Goldstein.
Thank you. May it please the court. I'm Cliff Goldstein. I represent Federated. Let me answer the question that Mr. Siegel didn't. And that question was, why is this a term of art? And how come this gets to be a term of art? Well, obviously, it's not a term of art. It's our Attorney General, for example, called it inflated, fictitious, flawed, constituted common law fraud, misrepresentation, civil conspiracy. That's not my opinion. That was why the Attorney General sued, because the average weekly wage was being interpreted as Red Book. In order to be a term of art, it has to be agreed to, almost universally agreed to, and it has to be agreed to in the right industry. There is absolutely no agreement as to what average wholesale price means. Mr. Siegel conceded it several times in his argument and in his brief. He said there were 3 publishers. There were actually only 2. The third, First Data Bank, went out of business as a result of the Saris decision in the average wholesale price litigation in Boston. But besides those 2 sources, let's question the logic of this. The Bureau says, the regulation says, you can pick any of the sources for AWP that you want, paraphrasing, of course. Why would it matter which one you pick if they're all the same? If there's universal agreement on what average wholesale price means, why does it matter which one you pick?
Well, because there has to be some kind of ceiling, doesn't there?
There is. The average wholesale price, meaning the average wholesale price. The literal definition. That's what the courts in Pennsylvania have held, not once but twice. That's what the courts have held in Mississippi. That's what the courts have held in Hawaii. That's what 2 different federal district courts have held. And that is now the law. May I submit? That is now the law in 3 states that have abandoned AWP and enacted NADAC as their
Yeah, but NADACA is a different standard from AWP.
Of course.
The CMS, if you look at the CMS bulletin that went to NADIC in 2005 or something like that, they specifically said exactly what you're saying. AWP is bunk now, but they say AWP is bunk.
Yes.
They don't say average, they treat AWP as a term of art that equates to bunk. And so AWP here is a term of art that equates to bunk, which is why, as CMS has said, we're not using AWP anymore. They don't say we're creating a new AWP. No. They say AWP itself is a pariah. It's gone. We're gonna create this new thing called NADIC.
Well, let me be clear.
I mean, I'll read it if you want me to read it.
No, I appreciate what you're saying, Your Honor, I do. NADAC is literally the national average of the acquisition costs paid by pharmacies to obtain drugs at wholesale. Now, his argument since day one has been the words Red Book don't appear in that definition, therefore we're talking about apples and oranges. Talk about splitting words and semantics. The dictate of the statute is average wholesale price. They could have said Red Book. You know what? In many states, they do say Red Book. My colleague is correct. Incidentally, in those states, they also place limitations on Red Book. They say it's the lower of Red Book or usual and customary, or they say it's Red Book, but not to exceed the federal upper limits, which is the standard used by Medicare. There's all sorts of programs out there that define average wholesale price, but none of them define it the same way, and that's the key.
You could flip that argument on its head. You could say that if they wanted to use, if they wanted to embrace this NADAC, they could have today, tomorrow, the day before, changed the law to say average acquisition cost, but they didn't. They kept AWP in the law.
You're absolutely right, Your Honor. And the question is, that's before this court, is whether we have to wait for the legislature to use the words NADAC or some other word, or whether this court is bound to determine whether the Commonwealth Court erred when it applied a plain language definition to average wholesale price.
Well, but NADAC, you agree that NADAC is not AWP.
No, Your Honor, I have to disagree with you.
CMS says it's not. CMS says it's something different.
I'm challenged, Your Honor, by that proposition. Average acquisition, the NADAC is a survey of pharmacies' actually paid prices to acquire drugs at wholesale. Did they use the words, and therefore it is the AWP? Maybe not. I don't know. Your Honor's probably right. Maybe
in late 2009, a working group within the National Association of State Medicaid Directors, NASDMD, convened to discuss various alternatives to AWP.
Yes, meaning alternatives to the Red Book.
No, alternatives to AWP.
No, Your Honor, I
which
have
they
to disagree.
defined as a drug pricing benchmark utilized for covered outpatient, a drug pricing benchmark utilized for outpatient drug ingredient cost reimbursement by state Medicaid agencies.
Bingo.
However, this benchmark has been the subject of much scrutiny and litigation over concerns that many AWPs were artificially inflated.
Yes, the benchmark AWP is Red Book. That's what they're referring to when they say this benchmark. AWP, Red Book. That's why we're here. Does AWP always mean Red Book? Or was the Commonwealth Court entitled to say, you know what, that leads to a bizarre and absurd result? My colleague mentioned the cost of gabapentin. What he didn't tell you was it's not $8 or $12 or $80. They charged $800 in this case. The average charge by this pharmacy was close to 50 to 100 times higher than normal prices. If you go across the street to CVS and say, I'd like to pay as much as I humanly can for gabapentin and slap cash on the table, they'd throw you out of the store if you tried to pay $800 for it. It's not the cost of the drug, and it's certainly not the average cost of the drug to acquire it at wholesale.
That seems a straightforward argument, but how, aren't you flying in the face of this court's decision 11 years ago in TAP? Because there, this court, in an opinion by then Justice, later Chief Justice Saylor, recognized AWP as a key industry benchmark and called it a misnomer, given that it reflects the manufacturer's asking price rather than any actual mathematical average, but said that it's widely understood since the very early 1990s, even before the General Assembly, made its changes. So, wouldn't, for you to prevail here, wouldn't we need to revisit and change what we've said about AWP in the past?
No, because Justice Brobson is correct. There was a time in history. Oh, sorry. There was a time.
Apologize to me.
There was a time.
It happens from time.
There was a time in history when pharmacies were honest and manufacturers were honest. And when the manufacturers asked, what is your average wholesale price for this drug? They answered honestly. But then something horrible happened.
Yeah, but that's the point, is when AWP was put into the statute.
Yes.
The General Assembly knew what the indexes were, they knew what they were looking at, and they picked it because that's what medical assistance was using at the time.
There's the rub.
Since then, the General Assembly has changed statutes and regulations in Pennsylvania for medical assistance, still keeping AWP, but talking about EC and WAC and PDQXYZ and a whole bunch of other different things. But why isn't that the problem? We have to look at what the General Assembly intended when it drafted the statute.
Yes.
And back then, everybody knew what AWP was.
Yes and no. Back then, they knew that AWP was real. So a drug like pregabalin had an AWP of $8, and what the legislature said, because remember, it's a limitation, not a schedule. We don't have a fee schedule in Pennsylvania. We have a limitation. So they said, either pay X, but don't you ever charge more than $8 plus 10%, real average wholesale price plus 10%. The problem, I wish that I could change a lot of legislation in Pennsylvania, but we don't get that option. We only get the cases and the issues that are brought in front of us for resolution. The issue brought in front of the Commonwealth Court for resolution was, shall AWP be a fixed permanent meaning of Red Book since time immemorial and forever, or does that cause a bizarre and absurd result? And is a court, in this case the Commonwealth Court, and hopefully the Supreme Court, are you free to determine that the statute means what it says? They didn't use the word Red Book. There are places in Pennsylvania where they do use the word Red Book. Counsel pointed them out in his brief. But they never used the phrase Red Book in workers' compensation. And you know why? Because remember the genesis of this act, and this act, Act 44, 1991, 30 years ago. The reason this act was passed was to control costs. It was a medical cost reduction act. Justice, I think what you're arguing is that the legislature intentionally imposed a Red Book standard which would increase the price of a drug 100-fold.
You keep going to the Red Book issue, which I understand why you're doing it, and I understand the somewhat linkage. But here's here's I think where this case is very difficult based on what you're arguing. Your view of average wholesale price, as the General Assembly put it in the statute when they put it in, was generic. They literally meant average wholesale price.
Which at the time was synonymous with Red Book.
Well, which at the time, the indexes available, more like Justice Weck brought up the car prices, yes. NADA or Blue Book. There are many indexes available that supposedly captured average wholesale price. And at that time, even those indexes were pharmaceutically manufactured self-reported indexes, basically MSRP or whatever. They were created by...
But they were honest.
Agreed.
Yes.
But the General Assembly, when they used average wholesale price, knew that those were the references, knew that those were the indexes, knew that was how AWP was calculated, and they used AWP. They adopted it. Now, what's happened since then is there's been abuses by the reporting pharmaceutical companies, which caused medical assistance to go away. But you want us to actually believe that when the General Assembly said average wholesale price, AWP, back in 2000 or whatever, or 1990, whatever, I can't remember when this amendment happened to the Workers' Compensation Act.
93, I think.
93. You want us to believe that, notwithstanding what was happening on the ground at that time, and everybody knew what AWP was, it was a self-reported, indexed, verifiable number. Because of the abuses, you want us to now retroactively say, oh no, AWP actually means average wholesale price, whatever it happens to be down in the future, but that's not what was on the ground.
Your Honor, you're missing one step. You have the statute and then you have the regulation. And the regulation specifically allows the Bureau to pick a schedule of average wholesale price.
I agree with you. That's your tire jockey argument. Your tire jockey argument is that picking the Red Book is an abuse of discretion or is unreasonable.
Which is done almost annual. The council misspoke. The Bureau hasn't done it for a few years. God knows why. They've ignored the decision of the Commonwealth Court. They certainly didn't appeal it, and they ignored it. They were told to come up with a new schedule that complies with the statute.
But no states come up with new schedules. No states come up with their own AWP.
Or have so far, the NADAC.
That's not it. Okay, we're going to have a disagreement.
That is an average wholesale price, Your Honor.
If you read CMS's guidances on they treat AWP differently.
I understand what you're saying, Your Honor. I respectfully disagree.
Okay.
Let me move on to the second issue.
I'm not right on that.
You're right on the other issue, which is the PROTS issue. You're right on the PROTS issue, because we have a problem.
Counsel, before we move on to Protz, I mean, following the discussion with Justice Robson, I mean, the fact of the matter is that the Red Book no longer reflects AWP if that was, in fact, what the legislature intended in 1993. So it may very well have been that the Red Book reflected AWP, but it no longer does. So now we're left with the plain language of the statute,
Precisely,
which
Your
is average wholesale price.
Precisely.
We can't ignore the fact that the Red Book is no longer reflective of what the legislature intended in 1993. It doesn't make any difference that it reflected AWP at the time it was enacted. That was a coincidence. That was a coincidence. But now we don't have that. We know from the Red Book that it is not an average wholesale price.
I agree, Your Honor.
They published that is not an average wholesale price.
It's, as Summit's experts said, they're not even in the same city. You're talking about prices that could be 100 times normal, and that's required under a, quote, cost control legislation? Something's gone horribly haywire, and I think the answer might be Protz. What the Bureau has done is the Bureau's decided for itself that average wholesale price has one meaning, and that is Red Book, forever and always. Has been, will be, till the day we all die. And Red Book is the ultimate in a Protz issue. Why? Because it's a private company, whereas the AMA, you could argue, has some interest in public good or public health. You can't make that argument for Truven. Truven is owned by an offshore Cayman Island venture capital fund. They publish the Red Book for profit. In their own explanation of Red Book pricing, they admit not only that it isn't an average wholesale price, they embed several elements of discretion within Truven to pick this, pick that, pick the other thing, never tell anybody why or how. They have complete jurisdiction over establishing the drug price used by the Bureau to resolve disputes in Pennsylvania workers' compensation. That's unlawful. You can't delegate that legislative authority. Almost every state other than Pennsylvania has a fee schedule. If it's aspirin, the price is $4. We don't. We don't have a fee schedule. The best we've got is Truven. Please use the Truven price. The Truven price was concocted, and I use that word deliberately, concocted by drug manufacturers, reported without verification, without any type of guidance or assistance from the legislature, and without any opportunity for supervision or veto or vote by the citizens of Pennsylvania.
Is there a difference, Counsel, with Protz, because that was a legislative delegation? Here it's the Bureau saying Truven this year, and that presumably if abuses were shown, you could go to the agency, to the Bureau, and say, look, Truven is, out to sea. Well, literally in the Caymans, but we want to use, X, Y, or Z instead, and they could change that on a dime. Is that a difference?
It might be
distinction without a difference?
I think it is a distinction without a difference, and we're one level up. It's not the Bureau's designation that's the problem. It's the Bureau regulation that's the problem. Bureau regulation says go pick any AWP you feel like, whereas the Bureau interpreted that to mean Truven over and over again. The one other thing I want to say about the Protz issue is where and when and how the AMA changes the guides, which I think is it's only up to, what, 8 editions in 50 years or something. They change it infrequently, and the infraction was they can change it at will without supervision or direction from the legislature and ultimately from the voters of Pennsylvania. Well, pardon the pun, but this is Protz on steroids. This is an institution that we know they're making up phony numbers for phony reasons. God only knows how they concoct these numbers. But we know they're fake, and we know we can't supervise them, and we know we can't control them, and we know we can't change the parameters. We know, God knows when they change them or how frequently or on what basis. And we're stuck with them. This is an enormous issue. I'm sure the court appreciates how enormous this issue is. We're talking billions of dollars have been paid, overpaid, in workers' compensation. because workers' compensation pharmacies, and I'll use that term in quotation marks, workers' compensation pharmacies like Summit choose to charge the Truven Red Book price. As Your Honor pointed out, go to a pharmacy and try to pay the Truven Red Book price. They'll laugh you out of the store.
Can I ask a question? Is consumer price index a term of art?
Consumer price index, a term of art. I don't know, Your Honor. My gut tells me that it's not, that it's defined somewhere, that there's some piece of congressional or regulatory finding of how it should be determined and when it should be determined and who should determine it and how it's verified and to whom it's reported.
So let's say this. If the General Assembly had a statute that tied a certain payment or increase in payment to the consumer price index as reported by the Bureau of Labor Statistics for the Baltimore, Philadelphia metro area as of November or October 15th, whatever the year is, and it was determined that, oh my gosh, that's really not the CPI anymore. That is a completely ginned up, increased statistic that doesn't have any validity anymore. Does that transform CPI into what a normal term of art? And allows the Commonwealth to create its own CPI?
Well, not exactly. I think there's two components there. One is that it's the government. And say what you will about government at each level, there's a certain air of credibility to the concept of a number being published by the government pursuant to regulations and guidelines and administrative decisions. Here you're talking about Truven. You're talking about an offshore venture capital fund determining this index that you're referring to, which we know and they admit is false. It has nothing to do with average wholesale price. So can a state determine its own consumer price index? Probably. You know, there are some states that determine their own average wholesale prices. You can do it. You just call up every pharmacy and ask them how much they paid for the drug at wholesale. There's only, 15 drugs here, 6 drugs here at issue? Let's call up the pharmacies and ask them how much they paid for wholesale. You know what Mr. Siegel will never tell us? He'll die first. He'll never tell us what Summit paid to acquire these drugs at wholesale. And you know why? Because once you burst that balloon, once it becomes common knowledge that they're charging prices that are 50, 100 times higher than their acquisition costs, then you got to scratch your head. You got to go back to the statute and say average wholesale price. Did they mean 100 times prices that you acquire drugs at wholesale? Let me just make one more point. I appreciate your indulgence. Let me make one more point while I'm on a roll. And that is, I wanted to address Mr. Siegel's argument about an appealable decision because I've never had the privilege of serving in the capacity of having to judge a case. But there is an out, so to speak. I'm not sure that this is an appealable decision. And I've argued in the brief why I don't think it's an appealable decision. This case ended in a remand order in 2 directions. One direction was, please go back to the hearing officer and try again. And the other direction was to the Bureau. Please go figure out a schedule that complies with the statute. You see the Bureau here? Bureau didn't appeal. There's no appeal. The Bureau never appealed the order to come up with a new pricing schedule. So I would argue that the best thing for this court to do is dismiss the appeal. It's untimely. Let the Bureau do what it was told to do. Let the case go back to the hearing officer and let them apply the new schedule to the facts. Mr. Siegel will tell you, well, that's a legal impossibility. It's impossible for the Bureau to come up with a schedule of average wholesale price that means the average cost of drugs acquired at wholesale. Nonsense. We can argue over the semantics, but the reality is NADAC is a reported, nationally published index, a survey of actual prices paid by pharmacies to acquire drugs at wholesale. Does the report say average wholesale price? No. It says NADAC, different term. But this term means it. AWP doesn't. AWP isn't the term of art. It's an inside joke. It's
an inside joke the General Assembly adopted in the 1990s.
Well, and incidentally, it's also an independent, it's an inside joke among one industry, pharmacies and pharmacists. Mr. Siegel has purported that among pharmacies, AWP has a special meaning. You know who it doesn't have a special meaning to? My client, who for years, for decades, even in this very case, paid for these drugs not knowing and not realizing that they'd been duped, that they were paying 50 times more than real average wholesale prices.
Even despite all those years since the TAP decision?
Unfortunately.
And I guess, look, connect that to this final question, and I'll let you respond, is that, like, listening to you, well, there's a lot of appeal to your arguments, as there were with Mr. Siegel's. It's an interesting case. I guess my question here now is, what you're asking us to do, in one sense, I think, is to change the rules of the game. It may be a game that you would view as corrupt, or, I don't mean criminally corrupt, just, and I guess I'm wondering whether it's really for us to impose that change, regardless of the misnomer aspect. I mean, this court put everybody on notice 11 years ago that it was a misnomer, not that people didn't know, but if it's way out of whack, as you say, and it may well be, isn't that really something the General Assembly needs to take the reins on rather than us at this point?
Ultimately, yes. Shorter term, the Bureau was told to come up with a statutorily compliant schedule, and they blew the court off. They didn't appeal. They didn't request a stay. In fact, this court denied a stay. You know what they did to the court's stay? They ignored it. And to this day, they've done a few things. One, they've refused to publish any schedule, whether it complies with AWP or not. They just aren't publishing it. And
Maybe they're on vacation in the Caymans.
Your Honor, I understand your point. This is not a slam dunk. This is a difficult issue, and it has an enormously point.
Can I ask you a question? If you were the legislature and you could revise the statute,
Yeah.
how would you revise it?
I would revise it pretty much the way California did and several other states did, which is to say the price shall be determined as follows, and then you give a list of three, and the order is to pick the lowest, because the goal is cost control. One, NADAC plus a dispensing fee, and that's only fair, and I agree with that concept. Two, usual and customary charge. If you can go across the street to CVS and buy it for $18, don't charge the comp carrier $800. And the third standard, fine, throw in Red Book, be my guest. The point is that it'll always be the lower of the three, like in California, where it's either NADAC plus 10% or the usual and customary charge. I wish I could write a lot of legislation in Pennsylvania, but I don't get that privilege. And unfortunately, neither do your honors. But you do have the opportunity here to correct a tremendous injustice.
All right, we understand both arguments. Very well done. Thank you so much.
Thank you.
Thank you, your honors. Appreciate it.
Mr. Minner, the court is going to stand in recess until 1 o'clock. afternoon. Would you call the next case, Mr. Minner?
Thomas Miron versus the Delaware County Tax Claims Bureau, representing Delaware, Mr. Thomas Jr., St. Kelly, Mr.
In this discretionary appeal, we must determine whether a mortgagee of real property is entitled to notice via certified mail under Section 602 of the Real Estate Tax Sale Law prior to an upset tax sale of that property, or whether notification by publication suffices. Relatedly, we must consider whether requiring only notice by publication for mortgagees prior to upset tax sales runs afoul of the Due Process Clause of the 14th Amendment. Please proceed.
May it please the court. Good afternoon, Your Honors. My name is Hans Herbert Solom Jr. My attorney ID is 20593. Alsyrawan was granted in this case with the query for clarification as to whether 602 requires a mortgagee prior notice of an impending tax sale before the sale can take place. Your Honors, the relevant section of 602 relevant to this matter is codified at 602 E1. At least, and I'll read from the statute, at least 30 days before the date of the sale by United States certified mail, restricted delivery, return receipt requested, postage prepaid to each owner as defined by this act. Owner is defined in the act under section 101. It says, the person whose name the property is last registered, if registered according to law. And there's some additional language there. But in the case of First Pennsylvania, included in the grant of Alsyrawan, the court therein quoted the relevant section as person whose name the property is last registered, if registered according to law, and in other cases means any person in open, peaceable, and notorious possession of the property as apparent owner or owners thereof, or the reputed owner or owners thereof in the neighborhood of such property as to property having been turned over to the Bureau by any county owner shall mean the county. I've noticed in the court's reference to that particular section, they have left out the current, a part of the current section of the definition of owner, which also includes, if not registered according to law, the person whose name last appears as of owner of record on any deed or instrument of conveyance recorded in the county office designated for recording. Well, Your Honor, the state of Pennsylvania has designated the Office for Recording under 21 PS Deeds and Mortgages, Section 151, the Recorder of Deeds. Now,
Fortunately, we have an expert on that subject on our bench, Justice Webb.
Well, I was actually Register of Wills.
Same thing.
But,
Same difference.
yeah. Wills, deeds, yes.
Yeah.
Sealing wax.
okay, thank you for that clarification, and I will acknowledge that the last section of the statute includes what the Tax Claim Bureau is supposed to do in the event they're unsuccessful in locating an individual that would satisfy that definition, and it's quite comprehensive down to the point of the yellow pages, which are no longer published as I understand it, but the statute requires that an exhaustive effort be made, be undertaken in the event you are not able to communicate with an individual or corporation who would satisfy the definition of owner. Now, the understanding or the application of necessity in this matter of notice stems from the original decision by the United States Supreme Court in the Mennonite case.
Counsel, before you go into the Mennonite case, can I just ask you to circle back, because you're kind of you're moving through a whole bunch of statutes very quickly. You haven't really focused on why is a mortgagee an owner?
Why is a mortgagee an owner?
Yeah.
Well, under the statute, the mortgagee is specifically referenced in 2 or 3 different locations.
But is it referenced in the definition of owner?
Not necessarily as an owner, okay, but as an individual who is the last name in whose, well, is the last, however it reads.
Yeah, look at the statutory definition of
Person in whose name
owner.
the property is last registered.
Person who's what?
Person in whose name the property is last registered, if registered according to law.
Right, but that's my question, is what is your argument that a mortgagee has a registered interest, or it meets that definition?
Because the title search in this matter would indicate that Thomas Miron was in fact the name who was last registered according to law against this property.
Last registered is, what do you mean registered as what?
As an instrument of conveyance. Instrument of conveyance is language that's now included in the definition of
You're
owner.
saying a recorded mortgage is an instrument of conveyance?
Yes, and Judge Castile, in his opinion, let's see here, in his opinion, delved into, yeah, here it is, Pines versus Farrell. That's Supreme Court, Pennsylvania, A48 Atlantic 2nd, 94, Pennsylvania, 2004. In this opinion, Judge Castile indicates that a mortgage is in fact a instrument of conveyance for purposes of establishing an interest in the property.
And what was
Well, interest is different from ownership, though. I mean, there are all kinds of interests. I'm surprised that you're fighting and dying on this hill rather than on the due process argument. Isn't the due process argument going to be your stronger argument?
That is the argument.
Well, you're trying to.
Myron never got notice of anything.
No, I understand the point about notice. I guess my point is, instead of trying to cram the mortgagee into owner status, doesn't it make more sense to say that his interest is being forfeit, whatever that interest is, without due process?
It is, in fact, being forfeited without due process, because the record is clear. No effort was ever made by the Tax Claim Bureau here to notify him of anything.
Right, so I mean, why are you trying to, well, I'm not trying to challenge your argument. Let me put it this way. Would you agree that the stronger challenge is the constitutional one rather than the statutory one?
Well, of course it is, because the statute is based on the constitutional interpretation by the United States Supreme Court. Due process. In that particular case, it was a mortgagee, again, who lost the property, but there was part of the statute that said that the upset sale wipes out mortgages of record.
Yeah, but counsel, that's no longer the case. The Section 609 amendments protect those particular liens' interests. So I think what first we have to do is identify what the interests we're talking about.
Okay.
Your client doesn't have an ownership interest. He's got a mortgage lien interest. After the Mennonite case came out, the amended Section 609 that protects your client's lien. So your client's interest, to the extent that there is any interest, is protected, is it not?
609 is the linchpin of the notice obligations of the entirety of the statute, because what it creates is an oxymoron when the statute says the Tax Claim Bureau can or must present a deed in fee simple to the successful bidder at the tax claim sale.
At the upset sale.
You cannot have a fee simple and a mortgage on top of it. You don't reach that point until you get into judicial sales, okay? Wherein the title to the property can be rendered allodial with no other claims, okay, against it. Wipes out everything.
Yeah, but
you don't reach that here.
You don't take the title at an upset sale not subject to the mortgage.
Yes, you take it subject to the mortgage.
Subject to the mortgage, so your client's mortgage interest, which is what we're talking about here, is protected.
It's
In other words, if I go at an upset sale and I buy a property for $5,000 and there's a $100,000 mortgage on the property, that mortgage is still a priority lien on the property against my interest.
That's correct. But what you've lost, what the mortgagee has lost is an opportunity to redeem the property, to enter into a
But he's never
periodic
had-
payment plan, and even to sell the property during that period of the periodic payment plan to pay the mortgage off in full. Those opportunities are a lot less expensive, a lot more productive, quicker, faster than having to go through a mortgage foreclosure proceeding.
I don't understand how you would go through, so you acknowledge that your mortgage is still intact?
Yes, it's still intact.
Okay,
Pursuant to
so-
609.
Right. So you're saying what you lost was remedies that you would have had to foreclose. Was the mortgage deficient? Was it being unpaid?
Mortgage is current. I mean,
Okay, I'm trying to figure out what you lost.
It's still a valid mortgage.
Right, so how are you aggrieved?
You're aggrieved because you have to go through a mortgage foreclosure proceeding.
No, you don't. You said it's current.
Well, it's still on the records. It's still a valid mortgage.
Right, no, but you're saying that the mortgage is being paid.
No, it's not.
Oh, it's not.
The mortgagee is now the owner of the property.
Right, but they're not paying?
There was a deed in lieu issued after it was discovered that this upset sale had taken place.
Sure.
And the deed in lieu was issued pursuant to the mortgage redemption rights under 609. If your mortgage is still valid,
Right.
still valid on the books, then all of your remedies under the mortgage that's still valid on the record are available.
That's your problem in the case.
The deed in lieu was filed so that now the mortgagee owns the property, okay? Subject
To your lien, to your
To your
lien.
lien.
So that's why your case is different than Mennonite.
I'm sorry, different than
That's why your case is different in orders of magnitude from the Mennonite case.
Well, that's right, because the mortgage is still intact because of 609, but it forces the mortgagee to have to go through all this foreclosure action, and he loses the more expedient.
Well, that's what I don't understand. Is there a default on the mortgage?
Is there what?
You keep bringing up foreclosure. Is the mortgage in default?
No, the mortgage is not a default because
So you don't have to go forward with foreclosure.
there's a deed in lieu already of record.
I understand, but you keep bringing up the idea that you've lost your ability to foreclose on the mortgage. How have you lost your ability to foreclose on the mortgage?
You haven't. You can still do that, okay?
Right, so what have you lost as a result of the sale?
What we've lost is the time and effort we've had to come to court to resolve the issue.
What's the issue?
There was no notice.
No, I understand, but I'm trying to understand. You want sort of this resolution of this general legal proposition of should mortgagees get notice as owners under the statute, right? Okay. I'm asking you, how is a mortgagee aggrieved under this statute when they don't get notice?
How are they aggrieved?
Yes.
They've deprived of their constitutional rights of due process. That's
No, but
how-
what right are they being deprived of? You have to, in order for there to be a deprivation of due process, notice and opportunity to be heard, that has to happen before a right is taken away. What right has been taken away by you without notice and an opportunity to be heard?
So if you follow that line of thinking, every mortgage that's recorded would be saved by 609, and therefore Tax Claim Bureau would never have to notify any mortgagee, including banks.
Well, it is saved, every mortgage is saved by 609.
Exactly. But what it creates more litigation in foreclosure actions.
What, you keep saying, what foreclosure action?
A foreclosure action on the mortgage that still exists on the record.
Why are you foreclosing? If your lien is good, there's a new owner, what's the foreclosure?
Okay, there is as yet no foreclosure, but because we petitioned to set aside the tax claim sale, okay? But in the meantime, a appellees had filed a complaint to quiet title. So that has become another whole ball of litigation, okay, to resolve this conundrum of whether or not this...
Well, there's nothing this court can do to prevent people from litigating, but presumably, you're going to have full entitlement to litigate whatever they're trying to do down there. I mean, your lien is protected under the statute. What I thought you were going to say in response to Justice Brobson, but you didn't, was something to the effect of the mortgagee has an interest in who the new mortgagor is going to be. You might not like the creditworthiness of this new buyer. You might have some problem with whoever's taking title, and that you think you should have the chance to litigate in that mix because you have a security interest that needs to be protected, and you'd rather have A than B or C. But that apparently is not your argument.
I don't follow that. You have a statute here that says that a mortgagee is supposed to get notice of an upset sale. That didn't happen.
Well, you get pre-publication notice by mail, right?
No, they didn't receive any notice at all. None. We didn't find out that this property had been sold at an upset sale until the buyer walked in the door and said, I'm the new owner, get out.
Counsel, what would you have done if you'd gotten notice? What would your client have done if it had gotten notice?
What did they get notice
No,
of?
no. What would your client have done if they had gotten the notice that you're saying they should have gotten?
He would have gone in and paid the back taxes. It's simple enough. He had the right to do that under Retzel. There's a redemption period, or you can enter into periodic payments.
Wait, the mortgagee would have done that?
The mortgagee, yes, absolutely.
The lender would have walked in and paid the taxes and paid...
They have the right to do that. Under the statute, they have the right to do that. And the statute itself...
The mortgagee has the right to do a redemption.
Yes, because they have a instrument of conveyance, an instrument of conveyance which is protected under the statute by Judge Castile's opinion. Judge Castile says a mortgage is a conveyance. So under that language, which is not included in First Pennsylvania, and which is included, as of amendments and modifications of the Retzel that were in place at the time of the upset sale, okay? The mortgagee was deprived of his redemption rights. He was deprived of his opportunity to go in and pay the back taxes.
I know owners usually...
They never notified him until after the fee simple deed had been issued.
But you're making the... So all the arguments you're making, though, are instances where, as a result of the sale, someone loses an interest. And that's why, particularly, we're very strict about the notice provisions requirements to owners. So, because the owners are the ones that owe the taxes go with the land, and they have a redemption right to go in. Here, again, back to Justice Weck's point, and I guess it would be a good argument, I guess maybe a good argument if you made it, that you have the right to choose who your debtor is. But here, your client was in no different situation pre-sale and post-sale. Your client was in the exact same position. The position did not change as a result of the sale, other than the identity of the debtor.
That's if you define the definition of owner to a grantee on a deed. And that's essentially what...
No, I'm not talking about the definitions. I'm saying, I'll take one more shot at this. How did your client's position change pre-tax sale from, post-tax sale from pre-tax sale? How did your client's position change?
With a recorded mortgage.
No, I'm not asking you what you are. I'm asking, how did your position change?
How does it... Now he has to defend this action quiet title. Now he has to go through a process of mortgage foreclosure.
Well, you might have had to do, to Justice Weck's point, you might have had to done that anyway. We can't stop people from litigating.
And why is he going through a mortgage foreclosure?
Because, well, he will eventually, depending on how the court decides. If you set aside the tax claim sale, he won't have to do that because he already has a deed in lieu of foreclosure.
But are there mortgage payments that are not being made because of this conveyance? I mean, you keep talking about foreclosure, but I didn't understand where you said the mortgage was not being paid.
No, the property is rented. The tenant is paying a monthly rent. the mortgagee is collecting that rent.
Okay.
The mortgagee is currently under court order to pay into a judicial escrow the balance of the rent collected minus homeowner association fees and insurance and things like that. So even though a fee simple deed was issued to the appellees, the successful bidders at tax claim sale, they have received nothing in terms of rent or mortgage payments or anything like that at all. It's all being paid into a judicial escrow. So all this confusion is generated by the fact that the courts have not upheld the letter and spirit of the tax claim.
But that just presupposes.
Notice.
You keep saying that, but you're continuing to presuppose that a mortgagee is the same as an owner, and there's nothing in the statute to support that.
And you keep referring,
There is, Judge Castile's opinion and the instrument of conveyance.
okay, just one second. Chief Justice Castile's opinion that I think you're referring to referenced an interest in the conveyance. Did he determine that a mortgage was an instrument of conveyance?
Yes. Yes, he did.
Counsel, what's the site of that case you're talking about?
I'll give it to you here in a minute.
Okay.
Here it is. It's Hines v. Farrell. It's cited as 848 Atlantic 2nd, 94, Pennsylvania, 2004. The issue, it's rather complicated. But
If you could just read the language you're referring to from Chief Justice Castile, I'd appreciate that.
All right, here. Here it is. Here's what Castile says. What definitely tips the balance in this court's view is that although a mortgage can be considered both a conveyance in form as well as a security interest for purposes of actions involving recording acts, mortgages traditionally have been treated as conveyances. That's what he says.
Conveyances of what?
I'm sorry?
Conveyances of what, though? You're talking about a conveyance of an interest, of a mortgage interest, as opposed to an ownership interest. That's a critical distinction, I think. When you talk about a mortgage is a conveyance of an interest in a financial interest, not an ownership interest. Because, in other words, I have a house with a mortgage. The bank doesn't own my house. I own my house. They've got a mortgage interest in my property.
You're correct, but Retzel says instrument of conveyance, okay? So it combines both of the elements that you're talking about.
But a conveyance of what? It's a conveyance of a mortgage interest or a conveyance of an ownership interest. They're two distinct things.
It's both. It's both because it incorporates instrument of conveyance in a general sense. A mortgage is a specific lien against a property, and Castile says that it is treated conventionally as, traditionally have been treated as conveyances. He uses the word specifically conveyances, and he doesn't distinguish between ownership and otherwise. That's the problem with the way the statute is written, is reference to the last name recorded against the property, and that in this case...
Well, can I follow up? Because the Section 102 definition of owner reads in pertinent part, the person whose name last appears as an owner of record on any deed or instrument of conveyance recorded. So it's referring back to owner. In other words, you're focusing on conveyance, but the statute is talking about an owner of record on any deed or instrument of conveyance. Correct. So the owner is still the owner. The mortgagee is not magically transformed into the owner.
But he's entitled to notice because he is included as an instrument of conveyance. He is a mortgagee. The mortgagee, the word mortgagee is referenced several times in the statute. Specifically, the first, in the opening paragraphs of the creation of the Tax Claim Bureau, it talks about distribution, and that, let's see here. Here it is. It's section 205, fourth, to mortgagees. After the sale has been conducted, the Tax Claim Bureau has to notify the mortgagee that there is an application before the court to approve it for confirmation nisi. the distribution, and the distribution has to specifically include notice to a mortgagee in the fourth section, even before owners, okay, which is only number 5.
Counsel, I don't know.
Mortgagees.
I don't know how that helps you, in the sense that the General Assembly clearly distinguished between an owner and a mortgagee in other parts of the statute. But when they defined owner, they didn't include in the definition mortgagee, even though in the sections that you're pointing out, there is a difference.
There may be a difference as far as you can see, but as far as the way the Tax Claim Act is structured, it's trying to be as broad as possible to bring in any and all interests of significant property.
I don't see that in the owner definition at all, and I'm flummoxed that your argument is attempting to recharacterize a mortgagee as an owner instead of arguing that due process demands that you have an opportunity to protect your collateral, to redeem your collateral, or to take steps that you think are needed to safeguard your collateral against a new owner that's going to be less creditworthy. You're not making that argument at all. You're making this argument about changing the word of the statute. I don't get it.
I'm not changing the word of the statute. I'm not trying to make the mortgagee an owner. I'm just saying the mortgagee is an entity that's entitled under the statute to the notice requirements of the upset sale. And he didn't get it.
Okay.
He's one of the category of people who are entitled, 1 through 5
All right,
of the distribution.
all right. We have heard this, and I think we understand what your argument is, so thank you. Let's hear from Mr. Syed. I may have pronounced your name wrong, sir.
Mark
Zaid.
Zaid.
Thank you, Mr. Zaid.
Thank you, Your Honor. Chief Justice Todd, Associate Justices, may it please the Court.
Could you pull the mic down a little? Thank you.
Yes.
Thank you.
Good afternoon now. We represent JAC Properties, which is the entity that acquired the property at the subject tax upset sale and was granted intervenor status by the lower court. My co-counsel to my right is Donald Weiss. May it please the Court. This appeal addresses whether a mortgage lien holder received constitutionally adequate notice of an upset sale under Pennsylvania's real estate tax sale law and the 14th Amendment Due Process Clause. In a tax sale, in an upset sale, the Tax Claim Bureau must provide 3 forms of notice to a record owner. They are certified mail or personal service, posting, and publication. In a upset sale, there is no requirement to provide notice in any other means by publication to a lien holder. That's clearly in the statute.
And by a lien holder, you're referring to a mortgagee.
When I'm referring to a mortgage holder, I'm referring to a mortgage lien holder who has a recorded mortgage lien against the real property. And then you'll see later on in the discussion, there'll be also judgment lien holders, people who acquire liens against real estate as a result of having a judgment. As I'm sure your justices know, a judicial sale is different from an upset sale. You normally have an upset sale first. It has a certain set of requirements for who gets notified, and then if that doesn't produce the sale of the property, then the next step would be a judicial sale. In a judicial sale, the property is sold free and clear of all liens and encumbrances whatsoever. So in that case, all notices must be given to all of the parties whose liens and mortgages you're going to extinguish by the judicial sale.
That includes mortgage holders.
That's correct. Okay, but in a tax upset sale, only the lien holders who had liens that postdated the lien of the taxes being sold are surviving the sale. They are not extinguished by the sale. They continue to have the same rights before the sale as they will have after the sale. So the need arises for a tax claim bureau to provide extra personal service to a mortgage lien holder only when the lien of that mortgage holder would be impaired or extinguished by operation of the tax sale.
That's under the statute, right?
That's correct.
requirement. But what about the constitutional argument? Could you see Mennonite being, let's say it went to SCOTUS on certiorari from us.
Okay, I'm getting.
Let's say you won here and they took cert to decide whether Mennonite should be extended to encompass a scenario where the mortgagee might argue, as I guess this appellant's not arguing, that due process would require they have an opportunity to play in the arena where these different potential owners are vying. So that if somebody comes in and they're not creditworthy, they have a bad history, or whatever, then the mortgagee might say, you know what, I gotta get involved here because my interest is going to be forfeit if I don't. How would you address such an argument?
I would address it this way, Justice Wecht. First of all, in the Mennonite case, clearly the mortgage lien was at risk of being extinguished as a result of the sale. Okay? In the two Pennsylvania cases, the First Pennsylvania Bank versus Lancaster case, similarly, the mortgage lien was junior to a prior tax lien, and that was at risk of being extinguished. Okay? In fact, in that case, the remedy was not to set aside the sale when it went back down and then came up to the Commonwealth Court. The remedy was to reinstate the lien. Of course, we don't need to do that here because this lien never was extinguished, never needed to be reinstated.
I totally get that. I think that's absolutely a good point.
Okay.
My only question is, maybe I'm just trying too hard here to see an argument. Maybe I shouldn't be. I guess I'm just wondering, like, let's just say there's a mortgagee, there's a mortgage lender, and this goes to a tax sale, and they didn't find out about it. And at this tax sale, instead of, PNC Bank or Mellon Bank getting title, it's, Joe Schmo who somehow beats the price and gets ownership. And he's a deadbeat from way back. He's defaulted all over the place.
Right.
And their lien exists in law. It's still the same lien, but their chances of ever getting their loan paid just went to nil in practical terms.
Well, keep in mind.
Could SCOTUS extend?
Yeah, keep in mind.
Extend Mennonite to that?
No, Your Honor, and Justice Wecht, no, because keep in mind the party who just lost the property was a deadbeat. Okay.
Yeah.
And keep in mind that the
The property's still there, right?
what's that?
The property is still there, the value of the property.
The property's still there in whatever value it has. If anything, the mortgagee, who has the same right to foreclose before and after the sale, is in a better position because somebody bought the property and paid the taxes. That would not have to be addressed by the mortgagee who's doing a foreclosure.
Can't be worse, you're saying.
It can't be worse.
Well, and if that were a good path to go, one would expect a record to be developed that that's what happened here, that the property was bought by a deadbeat. We're now in a worse position than we were previously. That's the property interest that has been deprived without notice and opportunity to be heard, but there's no record like that here.
That's correct. And the other thing is that when people buy at a tax sale, it's an unusual breed of buyer who's willing to take the risk to buy at a tax sale. They typically don't get the opportunity to see the property and its condition, okay? And typically don't see the opportunity to do a title report, to know the condition and the priority of different mortgages and liens and the amounts that are currently due on each of them, okay? So they're taking a risk. So they're willing to take a risk like that. There's also a risk of somebody being in possession of the property after they buy it. So these are all risks of people that take, but yet there are people out there doing it. And then there's thousands and thousands of properties being sold at tax sales for good reasons to promote, governments generating revenues and having stability in the process. I just want to continue on to some of my observations, if I may. In the upset sale, Berks County versus Schmumo case, this court extended the idea that judgment creditors, judgment lien holders, are entitled to some notice but if and only if their judgment liens were to be extinguished by a sale. By contrast here, the Miron mortgage lien was not extinguished by the 2017 upset sale. It survived the sale. The $100,000 mortgage in favor of Miron was recorded in February 2nd of 2015. The upset sale took place in 2014 of 2017. The upset sale was for the unpaid 2015, 16, and 17 taxes. The statutory scheme, that's quite extensive, that I outlined in the brief, this indicates that the earliest date when there could possibly have been a lien for unpaid taxes would have been in 2016, which was the year after the mortgage lien was recorded. So as a consequence of that, under Section 509 of the Tax Sale Act.
Counsel, can I just interrupt you for a second? Over here. Apologize. I'm trying to, there was an allegation or a claim that there's a whole bunch of litigation to quiet title going on here and things like that that could have been avoided. Is there something here that, the lender here, the mortgagee, is an individual, right?
Lenders, I'm sorry.
The lender here, the company that's challenged, the mortgagee is an individual?
It is.
Who owns the lien?
Yes.
Is there some sort of a connection between the lien holder, the mortgagee, and the defaulted owner on the tax side or something? Is there something we just don't know that makes this like a unique case that we should sort of know?
Well, there could have been. I'll be candid. The issue of the validity of the deed in lieu of foreclosure.
Of the what?
Could you pull that microphone closer?
You have to
you?
talk
I'm having
into
a
the
hard time.
The issue of the legitimacy of the deed in lieu of foreclosure that was done in 2019 after my client, JAC Properties, had taken a deed from the Tax Claim Bureau. That's the subject matter of the underlying case.
A deed in lieu of foreclosure.
From the prior owner. In other words, the prior owner, who no longer owned the property, signed a deed in lieu of foreclosure in favor of Miron, and the Delaware County.
So the former owner, after the tax sale,
Yes,
filed a deed in lieu of foreclosure of something that the prior owner no longer had.
that's correct.
Okay, so there may be something going on here.
Yeah, there's something going on, and there's an issue as to the validity of that deed, and even if some of it is valid, there's no affidavit of non-merger of the deed with the fee.
So the reason why we're pursuing this is because the way that deed in lieu of foreclosure becomes valid is if you eliminate the tax sale deed.
Well, it's possible.
If they can knock out the tax sale deed, the deed in lieu of
It's possible. In other words, if they had foreclosed, instead of taking the track that they did, they might have been in a different position. However, they're in the position that they're in, and they chose the remedy. And even the mortgages, even the deed in lieu of foreclosure itself recites the fact that as of its date, which was in December of 2019, that that the mortgage underlying it was valid and was unsatisfied. So on the snapshot date of the tax sale, leading all the way up to January or December of 2019, everybody knew and believed that the mortgage was not extinguished, was not impaired as a result of the tax sale. And that's the critical point.
So
That's the point
regardless of what happens in this litigation, the mortgage is still going to be valid, and he's still going to, Mr. Miron is still, has his mortgage interest in the property.
He may or may not, but that's not before you, Your Honor.
I know that, but that's what I'm asking you right now, because that seems to be the crux of this particular issue. That's what we're fighting about.
Yeah.
Does Mr. Miron have a valid mortgage interest in the property?
Well, we're challenging that.
Why?
Why?
Yeah.
Because
Just
when
when I thought I had this case figured out.
That's why I'm wondering about, because a mortgage foreclosure doesn't wipe out the taxes. An upset sale takes subject to the mortgage interest. He's arguing he's got a mortgage interest that's literally theoretically going to be wiped out.
Yeah.
Because his mortgage, that's theoretically what is going to bring this matter, the answer to your question, as to what Justice Wecht is trying to get at, which is...
Well, I think one explanation is that the mortgage, the underlying obligation is time barred. And if an underlying obligation is time barred.
So you're trying to wipe out his mortgage interest. That's why he's fighting the case.
Right. again, that's not a matter before this court.
You guys are engaging in a lot of litigation. I mean, but in front of us, the simple question is, were they entitled to, put aside all the, I don't want to say shenanigans, but put aside all the stuff that happened post-tax sale, all the litigation you're trying to do to harm him, that they're trying to do to, you know, deeds and lieu and all this other stuff that happened after the fact. Going back to the tax sale, which is right in front of us, the question is, immediately pre-tax sale and immediately post-tax sale, what was the status of the mortgage?
Completely valid.
Okay, when, in your view, did it become invalid such that you were able to start challenging it?
Either when the deed in lieu of foreclosure came from the non-owner that had no affidavit of non-merger reference in it, or after sufficient time, the underlying obligation of the note securing the mortgage became time barred.
Okay, but those are separate events that occurred after the
Both of those
deed in lieu.
events- Both of those
Not
events,
after the deed in lieu, after the tax sale deed.
well after the tax sale. So it's our position that that Mr. Miron had the same rights to foreclose on his mortgage after the 2017 upset sale, when it was purchased by Jack Properties, as he had against the prior owner before the upset sale purchased by Jack Properties. And as a result, he was not aggrieved by the 2017 tax sale and required no extra personal notice of the tax sale.
Counsel, you lost me there. You just said that he had the same rights before to foreclose on the mortgages after. You're telling us, you're challenging the validity of the mortgage. So did he or didn't he? I mean, when your clients bought the property at upset sale, I assume that you had
Our challenge didn't happen until a year later.
but I assume that the deed referenced the mortgage?
It did.
And the upset sale, you probably also had a title report which referenced the mortgage. So your
right.
client took with notice of the mortgage, right?
That's right.
Okay. I just want to be clear on that.
Now, Mr. Miron argued in his brief that his purported right of redemption was impaired by the lack of notice. But Section 1501 of the Tax Sale Act says that there's no right of redemption after an actual upset sale. Section 607G states that there's no right of exemption after confirmation title passes, and only liens that were not discharged by the sale are offered the right of redemption or to an owner. And there's an alternate redemption statute under the Municipal Claims and Tax Liens Act, which offers a right of redemption, but also only to those people whose liens were not discharged by the sale. So, looking at this thing from a practical standpoint, if this court were to require extra personal notice to all lien holders, even if not impaired or extinguished, the consequences and the collateral damage would be quite severe. Looking backwards, the statute of limitations to set aside an upset sale is 6 years. Hundreds, if not thousands, of upset sales of property sold in the last 6 years by the tax claim bureaus serving the 67 counties in this Commonwealth would be at risk of being set aside. This would create nightmares of practical and financial issues with buyers of properties, with their subsequent buyers, tenants, subsequent mortgage lenders, and title companies. It would also be contrary to a policy that upset sales are vital tools for local governments to collect delinquent taxes and maintain municipal services. Maintaining the integrity and the finality of upset sales, where lien holders' interests are preserved, protects both the government and the property owners. Looking forward, prospectively, for a tax claim bureau service, or for the group of tax claim bureaus servicing 67 counties to be required to identify and give personal notice to every lien holder, even when the lien holder's rights are not to be impaired or extinguished by an upset sale, would impose significant financial and administrative burdens on the tax claim bureaus. And if upset sales were routinely undone due to lack of lien holder personal notice, tax titles would be destabilized, creating uncertainty, additional litigation, and undermining public confidence in the tax sale process.
Are you telling us that you would be upset if we upset the upset?
I don't want to tell you what I really think, because I think there might be greater opportunities if you upset the apple cart than if you didn't. Let's put it that way. Here, we submit that the required statutory notice by publication of the 2017 upset sale given to all mortgagees was constitutionally adequate because Mr. Miron's mortgage was not disturbed and no extra personal notice to Mr. Miron would have changed anything when all of his rights were preserved, even after the 2017 upset sale. So we respectfully request that this court affirms the orders of the Commonwealth Court and the lower court, which found no basis to set aside the 2017 upset sale. Thank you very much.
Thank you.
All right, thank you both. Mr. Mayor, would you call the next case?
Pennsylvania School Boards Association versus the Secretary of Education of Pennsylvania. Representing appellants, Mr. Tom Powell, representing appellees, Mr. Michael Vance.
Hi, Jim. No, I think I'm good. Thanks, Jim.
Ready? This appeal concerns the Department of Education's decision to increase the age at which students with disabilities become ineligible to receive publicly funded education. For decades, under the school code, department regulations, and the department's federally approved state plan, students were eligible for publicly funded education through the end of the school term in which they turned 21. In 2023, following a federal class action settlement, the department rescinded that policy and adopted a new age-out plan, allowing students with disabilities to remain enrolled until their 22nd birthday. The department implemented and enforced the new policy statewide without going through formal rulemaking procedures under the Commonwealth Documents Law or the Regulatory Review Act. The Commonwealth Court concluded that the new age-out plan functioned as a binding rule, conflicted with existing state law, and was not already codified. Therefore, because the plan was adopted without formal rulemaking, the court held it was void and unenforceable. The department appealed and asks us to reverse that decision. Please proceed.
Thank you, Madam Chief Justice, Justices of the Supreme Court, and may it please the Court. My name is Thomas Howell, Deputy General Counsel. I represent the Pennsylvania Department of Education and its acting secretary, Dr. Carrie Rowe. I'm joined today by my co-counsel, Elizabeth Anzalone, Assistant Counsel for the Pennsylvania Department of Education. Your Honors, the primary issue to be addressed by this court is whether the plaintiffs, the appellees here, who do not appear to disagree that they must follow the requirements of federal law, may challenge the means by which the department communicates those federal requirements in order to allow them to discriminate against disabled youth versus non-disabled youth who are entitled to educational services under Pennsylvania law throughout their adult lives. Under federal law, however, where states make available educational services to youths through even adult education programs, which, by the way, are aligned with Pennsylvania's standards and curriculum for primary and secondary education, states may not exclude disabled youth from access to similar programs. In Pennsylvania, the obligation to provide special education services falls first on the state education agency, or SEA in the parlance of the Individuals with Disabilities in Education Act, and second on the local education agencies. The local education agencies, which are school boards and charter schools and others involved in primary and secondary education, are the entities that receive money from the federal government via IDEA and its grant programs to provide those services. One condition of accepting that money is that they provide a free and appropriate education in the terms of the IDEA to students between the ages of 8 and 21 years inclusive. There is no debate that the IDEA provides for 21 years inclusive, which is the entirety of individuals' 21st year of age. The only debate is whether an opt-out provision in the IDEA that had heretofore been relied upon by Pennsylvania and its LEAs provides immunity that allows schools to continue to discriminate.
Well, Mr. Howell, can I just jump in there for a second?
Certainly.
You say heretofore. The question is the Commonwealth still relying on the exemption? Because the exemption still appears in the Commonwealth's approved SEA plan, approved by the IDEA, approved as part of the IDEA by the feds.
2 points on that, Your Honor.
Well, is that true, though?
That is no longer the case in this past year submission to the United States Department of Education, in advance of which the department published notice in accordance with all of the terms and conditions of the IDEA. The department submitted modifications to its state plan to the USDE, which accepted that plan.
When was it accepted? For what school year? Effective what school year?
That plan was accepted, I believe, for this current school year, but I will confirm that.
Okay, and what school year are we talking about in this
It would
litigation?
be the 25-26.
That's the one that the new plan, the amended plan, is for, right?
That is correct.
Okay, what school years are we talking about here in this case?
This case originated, I believe, during the 23-24 school year.
So is it fair to say then prior to the 2025-26 school year, the old plan was in effect?
The old state plan was in effect. However, the genesis of this action was a challenge brought by an advocacy organization and...
No, I'm just trying to understand it, but the old plan was in effect.
So the old state plan was in effect, and that
Right.
state plan contained language that indicated, contrary to what was alleged by plaintiffs in the federal litigation and contrary to what was the actual practice of the provision of adult education services, that Pennsylvania did not provide general education.
No, I understand the impetus of the litigation. I'm just trying to understand the facts, and I think you understand where I'm going here.
I think so.
Can a LEA provide services, have a local policy and plan, enact an LEA plan? They don't have to adopt your model, but can they adopt their own plan?
Absolutely.
That conflicts with the state-approved plan.
Can they? Yes, they do so at their own risk. They certainly can.
I'm not sure, they can adopt, okay, let's try this. Is it lawful for them to adopt a model plan that conflicts with the approved state plan by the feds?
It is lawful. It potentially conflicts with the grant agreements that are executed between the USDE, PDE, and the LEAs, but it is not, as far as I can tell,
You don't encourage local school LEAs to adopt anything contrary to the plan. Because the plan is the contract with the feds to get the money.
That's right. And in
And if
fact,
the LEA does something that is conflicting with the plan, they risk not getting money.
that's true.
And what you asked them to do when you crafted this policy then, before you amended the plan, was to do something contrary to the federal agreement that you had in the plan.
Not exactly the case, because the plan was silent as to the provision of adult education services. So the plan, the opt-out in the plan is not an automatic opt-out. The opt-out is a provision that allows states to not provide services to disabled youth so long as they do not provide any of those services to non-disabled youth. And in Reichdoll, the Ninth Circuit...
Well, I'm confused. I thought you answered my question earlier that said that the old plan, the old state-approved plan included this exemption. that the department had been applying for years?
The old plan included language that indicated that Pennsylvania does not provide educational services to any individual, disabled or non-disabled, beyond the year of the end of the school year. Which
In the years that we're talking about here, before you sent that policy memorandum out, the LEAs were complying with the plan.
the LEAs were complying with PDE's interpretation of state law.
No, the plan. I'm not talking about...
That's not a term that's used generally in the special education space, compliance with the state plan, non-compliance with the state plan. They were complying with the IDEA as implemented and interpreted by PDE.
In the state plan.
PDE communicates its means of applying the IDEA via the state plan, but...
I mean, this is my problem. I think you finally did the right thing. I think you finally did the right thing. You amended the plan with the feds. The problem they have here is you didn't, and we're not talking about the Commonwealth documents law, because I'm talking about the plan, and the plan has the IDEA requirements that are separate from Commonwealth document law, which you actually complied with recently. So I think that's, or supposedly complied with recently. The issue is, can the department send a memo to school districts basically saying, you know, we know what the plan says here, but we now believe, as a result of litigation, we were wrong, and we're now saying why. Can you do that?
the answer to that question is yes. In fact, not only can the department do that, but the department's obligated to do that, particularly in this space where federal special education requirements are very evolving. And ultimately, the obligation is on PDE, not just in the IDEA itself, which requires PDE to implement and advise its LEAs as
What's the purpose of the plan?
I'm sorry?
What's the purpose of the plan then? If all you have to do is just send a memo to school districts that change the plan, that do something different to the plan, what's the purpose of the plan?
The plan is the indication to the USDE that PDE has in place the basic frameworks of compliance with the IDEA's requirements and supervising its LEAs. When we were challenged by the plaintiffs in AP, it became clear that there was a lapse, not only by us, but a lapse by the LEAs themselves.
They challenged the plan.
That exposed, they challenged the model policy as reflected in the plan. So,
Right.
yes,
Right. But you win you settle the litigation, and
Right.
instead of changing the plan, which there's a process to do to comply with the terms of the settlement, you sent this memo that sort of announced something new. And that's the question we're here today is, but what I wanted you to address, and I've now completely monopolized this time, and I apologize, this concern about this conflict with the state plan and the memo that you sent, and what is a local school district supposed to do to comply with, how do they comply with both?
The hallmark of the local education agency's compliance with the IDEA is compliance with the IDEA itself. That is the hallmark that the due process hearing officers adhere to. That is the hallmark that the IEP teams adhere to. So the state plan, while it provides a framework, is not a compliance document. It is not a document to be used to adjudge whether LEAs are executing appropriate means of compliance with and the provision of services to disabled individuals. It is a framework document that memorializes the types of programs and policies that the state education agency has in place to the federal government. So to say that school districts are somehow, by following PDE's guidance and, note, by actually complying with the IDEA, are somehow violating the state plan is a non sequitur. That is something that simply cannot exist, because if the state plan is inconsistent with IDEA, it is not a state plan at all. So there is no real conflict between...
There's no safe harbor.
Excuse me?
There's no safe harbor with the feds in terms of funding.
There is no safe harbor with the feds, and particularly there's no safe harbor with respect to students who are affected by this. And one of the questions that arose during briefing of this is what happens? What happens if this gets overturned? I mean, what happens if this interpretation of PDE is found to be incorrect? Well, as far as PDE is concerned, and this is the reason it's not a binding norm, nothing significant happens to PDE. What will happen is students across the Commonwealth will be forced to challenge the failures of districts who elect to not abide by the interpretation of the IDEA that provides for educational services to be provided through age 21 inclusive, and will have to do things like, for example, pay for compensatory education services. And this is part of this framework and the analysis that was at the genesis of this case, is the idea that, you know, if PDE doesn't act proactively, if it doesn't take steps, particularly in the AP litigation, to advise districts as to its understanding of their obligations, there are kids who are left catching up. And you know, we saw from COVID how difficult it is for students to catch up. That's what compensatory education is. Compensatory education isn't just we'll give this student 3 more months of school. There's learning loss that occurs over that time frame that arguably can never be regained. By communicating quickly and effectively and efficiently as it did, PDE was acting not just in accordance with its obligation under IDEA, but also with its obligation under the school code to advise schools on their approach to problems that they face in the implementation of all education laws. Appellees argue to the contrary, and ultimately, the argument has been one of whether PDE can communicate this way or that way. It's of note that the initial interpretation of the school code and the IDEA and how those interact was something that was not, in fact, regulatory. In that respect, this case looks an awful lot like the banking cases cited in my brief, in particular Cash America Net of Nevada, where, you know, the department had a long-standing interpretation that is based expressly on statute. Times change, law changes. The department explained that to the regulated community, and this court held that, in fact, departing from long-standing law when law changes is not a violation of the Commonwealth Documents Law. It is not a regulatory act. It does not create a binding norm, because that authority derived in the banking case directly from the Consumer Discount Act. In our case, that authority derives directly from the IDEA. And both Pennsylvania Department of Education and the various LEAs have an obligation to adhere directly to the terms of that IDEA, and cannot, when looking at individualized education plans, that is, plans for educating disabled youth, they cannot rely simply on the fact that, well, PDE has said for a long time that they don't think that we've got to educate kids beyond the end of the school year, even though the IDEA says that they are that they're entitled to education until they're 22.
You're missing the part. It's not that anybody disagreed that the IDEA goes through 22. The dispute is the department used to take the exemption by saying that Pennsylvania, because it's till 22 unless there's a state policy to the contrary. The change in opinion was not on through 22. The change in the department's position was the exemption. Everybody agreed what the IDEA says. It's just that the department decided, based on a settlement, we're no longer going to claim the exemption.
One correction, Your Honor. The exemption is not something that the department claims. It's not checking a box.
Well, it's in the plan. It's in the state plan.
It says that we cease providing educational services at the age of the school year in which one turns 21.
Right. That's in the plan.
Well, that
or it was in the old plan.
Well, and while that's true, that is not true for adult education services. The AP plaintiffs paid it.
We're not talking about adult education services here. We're talking about the school. We're talking about these school districts.
But they're the same. That's the issue. So when the IDEA examines the opt-out provision, when the IDEA speaks of what's being referred to as the opt-out provision, and what all of the circuits who have addressed this issue have determined, is that when public education, as a general term, is provided to non-disabled students beyond the age of 18, 21, in Pennsylvania it's frankly anyone over the age of 17, that when the state makes that available in a way that it is, quote, public education, the state may not deny that public education to disabled youth. The entities in Pennsylvania that are responsible for providing that public education to disabled youth are the LEAs.
But that's my point. That's the change in interpretation that the department engaged in.
That's not a
Nobody changed their interpretation of the through 22. They changed their interpretation of how the exemption, the state law exemption applies.
The department became aware that the...
Yeah, you changed. It's not a catch. I think everybody agrees you changed your interpretation
We
based.
certainly changed our understanding.
And you may be right now. You're probably right now.
And what's important about that is that that interpretation became clear when it became obvious that the education services for adults, which are provided under the WIOA Combined State Plan, which is the Workforce Investment Opportunity Act State Plan, it's a joint venture between a number of agencies, actually requires that those public education services be aligned to the Commonwealth's ESSA state plan. Another state plan, I apologize, there are too many. But the ESSA state plan is the Every Student Succeeds Act that forms the basis for primary and secondary education in Pennsylvania. In essence, our entire state education standards are developed as part of ESSA, and the adult education programs which operate under WIOA have to adhere to that very same education. They have to confer the same knowledge. So the assertion by the appellees here that adult education is something different, that it's some kind of correspondence school, that it's just for adults to come back and learn how to be machinists or something like that, it's simply not true. The adult education programs referenced in the school code operate under the published WIOA state plan, which is published in the Pennsylvania Bulletin. It's published at the U.S. Department of Labor and Industry, and it's very clear that we are obligated to provide services that teach to the standards of the Every Student Succeeds Act. We have to provide a primary and secondary education. That education is open to everyone in Pennsylvania over the age of 17 who has not attained a high school diploma. That public education is what was not being provided to disabled youth, and while they're not provided through the same programs, non-disabled adult youth use the public adult education programs. LEAs, by virtue of their existence as LEAs, are obligated to provide educational services, a free and appropriate public education, to every disabled youth between the ages of 8 and 21 inclusive. For that reason, the Commonwealth Court simply got this issue wrong. This is not a binding norm. This is simply the acknowledgement of what federal law already requires. This rule derives directly from the IDEA, and there was no appropriate reason to enjoin or otherwise overturn the department's issuance of this guidance subsequent to the AP litigation. Do your honors have any further questions for me?
Thank you very much, Mr. Howell. We'll hear from Mr. Levin.
Thank you.
Good afternoon. May it please the court. I'm Mike Levin. I represent the Pennsylvania School Boards Association. With me as co-counsel in this case, I'd like to introduce Anne-Marie Harrigal, representing the Pittsburgh School District, Carl Romberger, representing the Central Buck School District, Jocelyn Kramer, also representing Pittsburgh, and Tim Gilsbach, representing Upper Darby, and in the back somewhere, Carmen Bloom, Chief Legal Counsel for the School Boards Association.
Brought the whole team.
A big team. Your Honor, this case is not about the policy merits of extending services to age 22 for students. Reasonable people can disagree about that. The question before the court is far more fundamental. Who has the authority to decide, and what process does the law require before such change may occur? By order dated November 24, 2024, this court specified 3 issues that it wanted to hear argument on today. And interestingly, None of them deal with the IDEA issue and what IDEA requires or does not require, but I will have time at the end of my remarks to address the IDEA issue. The three issues that the court did ask for argument on converge on a single overriding principle. Whether the Department of Education may rewrite Pennsylvania statutory law, alter duly promulgated Pennsylvania regulations, and revise Pennsylvania's federally approved IDEA state plan through a private settlement and administrative fiat, or whether the department, like every agency in this state, must follow the legislative pathway, the regulatory procedures, and the public processes that the General Assembly and IDEA require. And Madam Chief Justice, one correction on your opening statement. The AP case was not a class action. It was a single plaintiff. Now, they threatened they were going to file a class action, but it never got, filed as a class action, never certified as a class action. Right. At bottom, this case is about the rule of law and whether the age of entitlement to Pennsylvania, to public education, set forth in Section 1301 of the School Code and 22 PA Code 11.12 of the regulations may be changed by memorandum and unilateral action. Now, the first issue is whether PDE's understanding of IDEA must be promulgated as a regulation. And we're not contesting their understanding. They could have their opinions however they want. We're contesting what they did. We're contesting what they are requiring school districts to do. This is more than an understanding. The answer is Section 1301 of the School Code needs to be amended. The regulations, if they're going to be changed, have to go through the Regulatory Review Act. The answer is no. I'm not sure the question you're asking.
I'm asking you the question, whether the department's understanding of IDEA federal law must be promulgated as a state regulation.
The answer is it must be. They can't do what they're doing. This is not just an announcement of an opinion.
I think it must be, and they have to go through formal rulemaking process. Not that just they can't do it by edict, because that's a Pennsylvania statute.
Correct.
I just want to be clear on that.
So under the court's jurisprudence, including going back to the mid-1970s, the Pennsylvania Human Relations Act versus Norristown, the court basically adopted the concepts that federal courts in rulemaking dealt with as to whether there be a binding norm. Does the change create a new substantive standard? Does it require compliance? Does it remove discretion from the agency, and does it have the force of law? I don't think anybody can reasonably argue that a new substantive rule was created. The old rule, you age out when the school year in which you turn 21 ends. That's what Section 1301 says. That's what 11.12 says. And that's what the state board, that's what the state plan said that has been approved for the last 20 some years. That's when you age out. In the settlement agreement, which, by the way, has typical language, parties intend to be bound by law, and contains a provision that the parties can enforce it with injunctive and equitable relief.
Can I ask a question about that? Who are the named parties in the, not the class action lawsuit, the lawsuit? Because it seems to me, if I'm representing the Department of Education in that particular lawsuit, before I actually enter into a settlement agreement that's going to obligate me to notify all of the school boards that they have to change their policy, I want to run it by them, and I want to basically run it by council, because it seems to me that the settlement agreement that they entered into was the reason that they had to alter this without legislative process. It kind of puts the cart before the horse. They probably should have tried to alter it as part of the settlement agreement or go through the legislative process. So, I mean, was your clients even notified of the lawsuit and asked to participate in it or agree to it? Because you're being bound by it.
Some people, some solicitors knew about the lawsuit because lawsuits get, people talk about them. A well-regarded education law firm in Montgomery County, Whistler Pearlstein, represented the school district. So they knew about it, and there were others who knew about it. Did anybody know there were settlement discussions? Did anybody know that this settlement was going to take place? Absolutely not. Not
So the
until
case
it
was settled. As
announced.
part of the settlement agreement, you were obligated to make certain changes. Okay,
Which had the impact of millions of dollars statewide.
understood.
And
But Counsel, I think that's a mischaracterization of the settlement agreement. Your client wasn't obligated to do anything on the settlement agreement. The Department of Education was obligated to take steps to implement its settled interpretation of the IDEA.
and to implement it, which means they had to take enforcement action against school districts.
Yes or no? Yes and no. I mean, I think it's vague for a purpose. I mean, this is not an odd settlement. There's a history of Commonwealth settling federal cases like this, and it's a pretty consistent viewpoint. Is they are going to do their best efforts to implement the terms of the settlement, which essentially resolved the dispute over the interpretation of the IDEA. And what they decided to do, they could have done a lot of things, but what they decided to do was send this memo that says, hey, y'all, new interpretation, be guided accordingly. We're telling you, you better do this, right? That's what they chose to do. They didn't choose to amend the plan. They didn't choose to pass a regulation. They didn't choose to go to the General Assembly to seek legislation. They kept the plan the way it was, and they did this. Let's say none of that happened, right? Let's say the same plaintiff that sued the department in federal court sued the Pittsburgh School District for violating the IDEA. Same argument, same issue. And would the school district be able to say, you know, Judge, you can't give them relief because we're complying with the state plan? If that is a safe harbor, and that even if the state plan is contrary to the terms of the IDEA, we are entitled to rely on the state plan, and that plaintiff can't get relief.
I wouldn't defend on the basis of the state plan. I would defend on the basis of state statute and regulation.
Well, that going to state statute, I'm just asking you, to me the issue in this case is, does the state plan give you guys any protection at all? Because if it gives you protection, if it guarantees continued funding, then I would say that's the binding norm. That's the binding norm that governs everything. But if it's nothing other than a piece of paper that the federal government just approves or blesses or what have you, and that these people who need these services can nonetheless still sue school districts, not even talk about the state plan and just say you're not complying with the IDEA. If that's true, then I think you're in trouble.
Well, Your Honor, it depends on how deep you want to get into the weeds with respect to the state plan. The IDEA is a funding statute, and under the funding provision of the Constitution, there are rules as to when something is required and not required. I would think that if a state plan was written and approved by the United States Department of Education and a state, and a school district complied with the state plan, it would be hard for anyone to argue that the rules should be different. But that's a funding clause argument as opposed to an IDEA.
So you're saying that in that hypothetical federal litigation that I'm talking about, the plan would take primacy over the IDEA?
Well, I would say it would be relevant to the interpretation.
You can't point to me. You can't point to anything in the IDEA or the federal regulations that say if an LEA complies with the state plan, they are protected.
Correct.
Okay.
I'm not aware of any such blanket rule. But
Counsel, I just want to clarify something too. You're not suggesting that the federal government, through this particular IDEA program, can order the states to comply. It's just like, as you said, a funding statute, because that would violate the 10th Amendment anti-commandeering statute. They can't force the states to regulate according to their terms.
No, the federal government can enforce the IDEA.
Wouldn't that violate the
enforcement
anti-commandeering,
mechanism.
wouldn't that violate the anti-commandeering statute?
I don't believe so, because it's part of the terms and conditions of getting the grant money. But some of the questions that were recently raised in this argument is whether the new rule was binding. And there's 6 reasons or 6 categories of evidence to show that it was, in fact, binding. The settlement agreement itself specifically says the old plan is out, the new plan is in, and the department's going to be enforcing the new plan. The pen-link directives to the districts, over 600 LEAs got this. You got to do this. The notice to the parents, thousands of parents. You're now entitled to education until your 22nd birthday. PowerPoint the PDE prepared for training. Several of the slides. You have to do this. The directives given by PDE at the training. This is mandatory, school districts. You have to do it now. Affidavits in support of the motion for summary judgment were filed. Not one piece of evidence was saying, no, you got that wrong. This is just our understanding. And then finally, there was no answer to the petition for a review that was filed in this case. As the Commonwealth Court noted, and as your Honorable Court is well aware, all of the factual averments are deemed admitted. There are at least 2 averments, paragraphs 43 and 52, which basically say PDE directed school districts had to start doing this. The second issue that was defined by order of this court was whether the department's amendment to the IDEA model policy was consistent with 1301 and 11.12, where PDE is arguing that both provisions require, rather than restrict, the provision of education. Your Honors, the Court's formulation of this issue traces directly from the 4th issue raised by the Department, beginning on page 39 of its brief, where PDE argues that 1301 of the School Code and 11.12 of the regulations, quote, require rather than restrict, end of quote, the provision of educational services. The Department's framing of this issue begins with a remarkable proposition. They say that Section 1301 and 1112, quote, do not apply to special education, end of quote. That's on page 40 of their brief, and therefore cannot limit IDEA eligibility. That assertion, quite frankly, is difficult to square with reality. It's contradicted by the statutory text and by the Department's own state plan. The very first substantive provision after the first few introductory paragraphs talk about the age. And in the state plan that's been approved for decades, it references and quotes Section 1301 because the statute applies to all children, not just special education children. So Department is arguing that somehow that section has nothing to do with special education when ever since IDEA was passed in the mid-1970s, the department has applied it, school districts have applied it, everybody in the field has applied it to applying to special education. Secondly, the framing of that issue assumes that 1301 and 11.12 are one directional, meaning that it has a minimum age but not a maximum. Well, look at the language. They both have maximums, and the maximum is the end of the school year when you turn 21. PDE changed the rule to now your 22nd birthday. Third, even if 1301 and 11.12 were not themselves upper limits, and to be clear, they are, nothing in either provision grants PDE authority to mandate public education beyond the upper limit. This court is well aware of the general proposition that school districts and other governmental entities only have the power and authority given to them by statute, by law. There is nothing that grants PDE the power to say, we don't care what 1301 of the school code or 11.12 of the regulations say. You have to go beyond this. They don't have that power. And school districts, quite frankly, I don't think have the power to educate beyond what the statutory language is either. And fourth issue on the framing of this issue is that PDE's argument seems to be based, this argument, solely on the language of the statute. However, IDEA, section 1412, subsection A1A and A12 are the two provisions that deal with the ages that students have to be educated. And A1A says up until the 22nd birthday, unless A12 says for kids between 18 and 21, if state law says otherwise, if state practice says otherwise, or if there's a court order that says otherwise, state law controls. And in this case, the undisputed evidence in this record is that state law says otherwise, that practice is in the state. We supplied affidavits from two experts in support of our motion for summary judgment. One, a former special education hearing officer since, I think, the 1970s, if not the 1980s, and the other from an attorney who concentrates his practice on special education and is perhaps the most well-regarded special education law. They define the practices. And the practices in this Commonwealth are you age out at the end of the year which you turn 21. Prior to 2002, when that was amended, you aged out when you turned 21. And then we have a court order. And the court order is the park consent decree. And unfortunately, I'm old enough to remember that and actually participated in some of the park enforcement hearings in the late 70s or the early 80s. That says 1301 is the law. So whatever the statute may say, we have past practice and no contradictory evidence, and we have the park consent decree, an order approved by the federal court saying 1301 is what we have to comply with. So here, all of the bases for the school districts doing what the school districts have done are checked, and we should...
So Mr. Howell, though, raised other statutes.
Excuse me?
He raised other statutes, ESSA, these other adult education statutes and things like that. You're saying they're not relevant?
Well, I have a couple of responses to those arguments, and I don't know that those remarks fit neatly within the three issues, but let me address that because it's important. Number one, the message seems to be changing from the PDE as to the reasons for their changes. Until I heard it today in oral argument, the only thing they were citing for adult education was the Pennsylvania Literacy Act, which has been in existence for almost 20 years. Now they're citing something else. I don't know what they're citing. I haven't had an opportunity to read the citations that he gave to us today. But that's not what the AP case was settled upon, at least according to what we were hearing when we were arguing this in the Commonwealth Court. But to get to those issues, let me say this about the Pennsylvania Literacy Act and the federal cases that were brought up. The four circuit court decisions basically said if you have adult education, it is, quote, public education for purposes of the IDEA if it provides secondary education. In other words, not everything that is done that has some tangential relationship to education is public education. And the decision that perhaps best explains what secondary education under the IDEA says is KL versus Rhode Island Board of Education, where the court said public education within the meaning of the IDEA includes the objectives of educating students up to the level of academic proficiency associated with the completion of secondary schools. Now, that's the only one of the circuit courts that actually defined it that way, but the other three are consistent with that. They were very vague, but they said it has to be secondary education. The only thing in this record is the Literacy Act itself. There is no evidence about all these other things that counsel said that Pennsylvania is doing and has done, etc. Not in this record. And if you look at the Literacy Act, the only thing the Literacy Act does is deals with adult literacy or family literacy programs. It makes no pretense that it's trying to give secondary education, offer secondary education in any way. I hope that answers your question.
I'm just trying to understand, it does, I'm trying to understand what a Rhode Island, is that like a GED? If the federal statute that required counties or school district to provide GED education, then that would qualify.
Yeah, the circuit court decisions all had, the courts found, after looking at evidence as well as a statutory framework, that they provided secondary education and did lead to either a diploma or a GED. They didn't all require the school districts to do it. Some of them had state agencies and those types of things. The adult literacy program has no thought that anybody's getting a GED or a diploma from going through those programs. And the reason is they're not secondary education, therefore they're not public education. I've spoken probably longer than I intended. I hope I've answered all your questions.
I do have one question. This occurred during the 23-24 school year. So what happened during the 24-25 school year?
What happened in terms of the practices of the parties? I knew you were going to ask that question, so I actually sent an email to school solicitors around. The answer I got is most school districts are complying as long as this litigation is in effect because they don't want to have to suffer the enforcement action from PDE. Some school districts are saying no.
So a mix across the state?
Correct. I think more are than are not, but it's because they don't want to deal with the enforcement. And I guess the one last point is the suggestion that the state plan has been filed and approved, which maybe I was negligent and haven't looked at public notices. I didn't know that until it was stated here. You can't change the state law by a state plan. And 1301 and 11.12 remain the same, and they haven't been changed.
I have one more question, sorry. In your application for summary relief, you sought enjoyment of appellant's change to its model policy in further relief as the Commonwealth Court may deem appropriate. Why didn't you request monetary relief?
At that point in time, I'm not sure I can answer the question.
I'm just assuming that the natural inclination is that you're requiring to enroll these additional students causes some type of excessive financial burden for the schools.
We did, and we put that forward. I don't know why we didn't ask for monetary relief.
Counsel, along those lines, what were the federal funding implications to the school districts as a result of this change? When the policy was changed after the school districts had gone through their budget process for the upcoming year.
Well, the way, the way federal funding works in the public arena, and I'm sure there are exceptions to every rule, the federal funding goes to the state, and the state distributes it to the school districts. We never got to the point where anybody was saying, if you don't do it, we're going to stop federal funding. That
Okay, so federal funding continued to flow to the school districts, whether or not they complied with the new policy.
as far as I know, yes.
All right, thank you both very much. Mr. Minner, would you call the next case? Case, appellant 700 Pharmacy challenges the Commonwealth Court's determination that prescription medications dispensed to several workers' compensation claimants violated the anti-referral provision of the Workers' Compensation Act because the prescribing physician had a financial interest in the pharmacy. Specifically, the Commonwealth Court acknowledged that the anti-referral provision does not expressly mention drugs, pharmacies, or pharmaceutical services, but concluded that the provision's reference to goods and services was sufficient to encompass prescription drugs, pharmacies, and pharmaceutical services, such that the prescriptions at issue were the product of a prohibited self-referral. We accepted review to consider the propriety of that decision. Welcome back, Mr. Siegel. I guess you never left.
No, and I'll be back tomorrow.
We'll look forward to it.
This case presents a critical question of statutory interpretation of the self-referral provisions of subsection 306 F131. And I say subsection because it's important in doing the analysis in this case of the various subsections of 306 F1 in general. And what it did, as the Chief Justice said, was it applied the anti-self-referral provisions to persons or entities that were not included. And the included provisions, and you have to read this statute, it's a little bit awkward because it says that notwithstanding any other provision of law, it is unlawful to refer a person for laboratory. Then it says physical therapy, psych rehabilitation, court, chiropractic, etc. But those don't have any context unless you read laboratory, goods or services, physical therapy, goods or services, rehabilitation, goods or services. The word for laboratory without context adds nothing to it.
There's a comma in there that appears to be misplaced or erroneous.
It could be, but it ended up in the final statute, and we have to live with that.
Well, some of the words preceding the comma are nouns, some are adjectives. It is a little bit confusing.
Yes, and more importantly, this provision is being applied in practice, even though it's not in this case, to other entities, ambulatory service centers, durable medical equipment. So whatever the court decides in this particular case, it's going to have an impact far greater than just pharmacies. It's going to impact all of these other entities that were not named in the provisions. And it's also important that you also consider the statute, the regulation that was adopted by the Bureau, which went well beyond the language of the statute and prohibited basically all self-referrals and did so that way. Now,
Well, that would only go beyond the statute. That would only go beyond the statute if one were to read the statute the way you're reading it. If you read the statute the way the Commonwealth Court read it, it speaks to goods or services, which would encompass essentially everything. I remember back in 7th grade learning about goods and services. That pretty much covers the waterfront. So why is it that pharmacy is not, drugs aren't goods or services?
there's a number of reasons for that. First, and it's important to read this contextually, because in the subparagraph of the provision that is at issue here, they don't mention pharmacies, drugs, or services. That's subparagraph 3, 3 with little Roman numeral little 3. Subparagraph 6 in the same provision does mention extensively pharmaceuticals, drugs, and that type of entity. And it does so not just, one is silent to it. It mentions drugs and pharmaceuticals and drugs 23 times. So the word drug or pharmaceutical appears in that provision 23 times. In addition, the legislature in the interim had amended part of the provision to include or to address the issue, which isn't relevant here as what they enacted, but it is for what the context is, which is they restricted certain in-office provisions in terms of doctors. So you have those two things going on, and yet in paragraph 3, they don't mention any of it. And if you were to accept your that interpretation that you just espoused, then you've then prohibited all self-referrals to all types when that was never sent, that was never by the express language.
Did you just tell us, Mr. Siegel, that elsewhere in the section, pharmacies referenced, right, extensively, right?
Yes.
So therefore, when this subsection says goods or services pursuant to this section, wouldn't one infer that that would include goods or services mentioned in this section that includes pharmacy?
No, because the specific language is relevant under the Statutory Construction Act, and in fact, in one of your cases, the in-rate trust under the deed of Kulig, you refer to that, where you have to look at the entire statute, and you have to look at statutes read as a whole. And if you read the statute as a whole, you see that there was apparently some legislative interpretation where they certainly know the language for pharmaceuticals, they certainly know the language for drugs, yet they purposely, or there was a conscious decision by the scrivener, whoever that or those persons were, to not include them in the self-referral provisions. In addition, when the Bureau promulgated regulations, they promulgated regulations under the Stark Act, which leads to further problems because the Stark Act and... Yes.
Just getting back to the Commonwealth Court's interpretation, if goods or services means what the Commonwealth Court says it means, then it would never have been necessary to specify laboratory, physical therapy, rehabilitation, or any of those other specific types of goods or services, because goods or services would cover everything.
Correct. And nowhere else in Pennsylvania statutes, when pharmaceuticals are they referred to as goods or services? Because they are a specific type of item, whereas goods or services, for example, laboratory goods and services goods could be the cup you have to use if you go to a urologist, or that type of thing, which makes sense in that context. But the goods or services is a phrase that is never used anywhere else in the Pennsylvania statutes, in the Clinical Laboratory Act, or in any of the others.
It's a term of art, like that other case you have.
Yeah.
Well, medicines and supplies are services.
Yes, but in Your Honor's decision in Schmidt, the language of 306F11 specifies medicines and services, not goods and services, and you applied it to that under, medical marijuana. But this provision doesn't include, that provision specifically was medicines and services.
Well, it was medicines and supplies.
Yeah.
Which trace back to services, not goods and services.
Right.
Right.
So
I'm
medicine.
not saying it's different. I'm just saying I'm kind of pushing back the idea that that pharmaceuticals aren't anywhere referred to as services.
Well, yeah, but they weren't referred to specifically as they are in the subsection 6.
Well, I agree with you on that. I'm just saying I think you said there's nowhere else in the Act where pharmaceuticals are referred to as services. And in the Schmidt case.
You adopted it that way.
Right.
Yeah. But it was medicines that you adopt. Your analysis, right? That's how I read that case.
You probably agreed with it too.
I did. But when you look at like the Stark Act, which was never mentioned in any legislation or anything else, you see also the dramatic difference in the regulation, because the regulation said we're adopting it, and the Stark Act prohibited a lot of other things that the section doesn't doesn't prohibit, and also some items in the section of the Workers' Comp Act aren't prohibited under the Stark Act. So it's not a fair analysis to just keep the two together because they're very, very different. But if we get back to the overall argument, the first part of it was that they don't have the same emphasis, and when you get to Section 3, it doesn't, as I said, doesn't mention it. But then for number 6, under that, and that's never been changed as to the major part of it is, it's the reimbursement for drugs and pharmaceutical services, and it goes on and on. So the legislature is presumed to have known that and used those terms, especially within the same provisions enacted at the same time by them. So it's not as if one was amended and one was not. So that's what I wanted to address there. Go back for a moment, get my notes. The other item that's important in all of this is the doctrine, and excuse me, I want to pronounce it right, adjustum generis. I don't use a lot of Latin, but that goods and services is not a reasonable expectation to include all of pharmacies, ambulatory service centers, durable medical equipment, and a variety of other items. Because if you're going to do that, then you don't need any of the specific words. There'd be no reason to do that. And that's essentially the interpretation of the Commonwealth, where they say it's goods and services, it's everything. And if that's the case, then you didn't have to, the prohibition would have been blanket prohibition.
Don't they do a lot of things they don't have to do? Don't they do a lot of belt and suspenders work?
At times they do, but this would be a dramatic expansion of the terms beyond what anyone.
Would it be dramatic to find that in legislation seeking to prevent self-referral that they tried to prevent physicians from prescribing to pharmacies they own?
It wouldn't have been.
That'd be pretty much a classic self-referral problem, wouldn't it?
It's one of many, yeah. But if you go by that, you can also look at the subsections that were amended right between them for in-office dispensing. And in-office dispensing was seen as a dramatic problem. And it was, an area for abuse. And as a result, the legislature stepped in and enacted amendments that really dealt with that, so that in-office dispensing was restricted dramatically so that a patient could, yes, go home with some medicine he needed, but the doctor was not going to become a dispensary or a pharmacy. But they did that, but still left untouched paragraph 3. And I think that's important in that analysis because they knew what was happening and they stepped in and they did it. But they didn't go into the self-referral and say, oh, we see there's a problem in self-referral to pharmacies or self-referral to ambulatory service centers. That it didn't happen.
So the distinction could be in practice between the doctor's suite dispensing in suite or sending them down the elevator to the first floor where the doctor's pharmacy is.
Well, it could, but and it could be, but they didn't see that as the problem because the pharmacies follow different. They have different laws that affect them, the Pharmacy Act, et cetera. So they're governed by different standards, and the abuse wasn't happening at the pharmacies, and there's not been any type of abuse that's been, at least legislatively dealt with on the pharmacies. So the pharmacies weren't the problem. It was the in-office dispensing. That's why they did that, and they didn't see that. And actually, you can have pharmacies in the same building, even if, and one of the issues is, yes, some of these are doctor-owned, but that's also a convenience for patients. They don't have to run. They go down there. They're still going to be governed by the limits, whatever they are, for, and that's for another case to be decided, but they still have, the cost containment rate regulations on those pharmacies. So they're not benefiting that way from it. But the patients are getting a doctor's office, and you see it in hospitals where the hospitals have the same thing. The pharmacies are in the hospital, maybe Walgreens or whatever company, but they're there because they want the patients to have that convenience.
Well, convenience can be, well, I mean, by definition, self-referral aims at dual income streams, right? I mean, if you're getting the fee for the service and then you're also getting the fee for the good that you have ordered, provided, then it seems to me that the kind of self-referral of goods or services that the legislature was getting at. No?
No, because they were very specific in what they chose. And, it is instructive to look at the Stark Act because the legislature could have chosen their words and their items very carefully. And there are some overlap. Clinical laboratory was in both, physical therapies in both, and that was dealt with in the 84 mining case. So we had that. But occupational therapy isn't covered under the Workers' Comp Act. It is under the Stark Act, things like that. Speech pathology outpatient isn't covered. Durable medical equipment, which is a large area of referrals because patients need durable medical equipment following injuries, all of that. Home health services weren't, but yet the Workers' Comp Act prohibited it in the context of chiropractic services, but the Stark Act didn't. Similar things like that. So the legislature did not either adopt the Stark Act or any other. They went in and they picked and chose their choices, I think, carefully in this context because they saw those areas for whatever, wisdom or lack of wisdom, as we've debated this in other cases, obviously, they chose. And it's not for this court now to go back, or the Commonwealth Court to go back and suddenly expand beyond that, especially because the general, his jusdom generis is they're supposed to be limited, the goods and services, by the items in front of it. And none of those items in front of it covers pharmaceuticals or pharmacies, or for that matter, durable medical equipment or ambulatory service centers, the surgical centers, and there's a large growth in those. And, they haven't seen any reason to deal with that. So as a result, what we have here is an overreach of the Commonwealth Court. The language, the plain language of the statute is clear. When the language of the statute is clear, you're supposed to abide by it and not enter into things. In the other case, yes, we had language which we were debating, but there's no debate in this language here. The language of what was restricted is very clear, and then it was modified only by goods and services. It wasn't modified by medicines and services. It wasn't modified by all those other words where it could have been. It could have been pharmaceuticals or anything. It wasn't. But immediately after, they put in a very detailed scheme. And you have to presume that when they did, they knew what they were doing. So I would ask that this court reverse the Commonwealth Court and enter its order accordingly.
All right, thank you, Mr. Siegel. Hear from Ms. Ehrenholt.
Good afternoon, Madam Chief Justice. May it please the court. My name is Casey Ehrenholt. I represent the appellee in this matter, the State Workers Insurance Fund. Your Honors, appellee is respectfully asking this court to affirm the Commonwealth Court's holding that the provision at issue here does prohibit this sort of referral from a doctor of a claimant to a pharmacy in which they have a financial interest. I will start off by noting that the Statutory Construction Act does provide that the object of all statutory interpretation is to ascertain and effectuate the intention of the General Assembly.
The intention?
Yes, Your Honor.
Why don't we just effectuate their words?
Your Honor, here we are looking at Act 44.
What?
Here we are looking at Act 44. As this court held in 84 Mining Company, the purpose of this provision was to contain costs under Act 44 and to stop doctors from acting in their own self-interest. So here, specifically looking at what the appellant argued, this is a provision, as Madam Chief Justice mentioned, that is confusing. There are nouns, there are adjectives. The Commonwealth Court has read this one way based on the plain language.
There's a wacky comma.
Exactly. We have argued in the alternative in our brief, first stating that we would like the Commonwealth Court to be affirmed, that this plain language here is obvious. This is a broad catch-all provision meant to...
Do you think it's unambiguous or is it ambiguous?
Your Honor, I do have a personal thought on this. However, I will state it seems there's about 3 different ways this could be read. First, the way the Commonwealth Court looked at it, which is that this is a broad, all-encompassing phrase that does capture this sort of referral to a pharmacy. There's also the way of looking at it that this is really just a qualifying language, that it should attach to chiropractic, laboratory, etc. It's unclear. There's precedent that this court has in the past held in cases such as McClellan and Herald versus University of Pittsburgh, where it actually seemed a little bit clearer than it is here. And the Commonwealth Court talked about its prior case in Bennett versus Jeld-Wen, where this is not what was at issue, but naturally it read goods and services as including drugs, pharmaceutical drugs in that specific instance.
What about the enumeration? What about the justum generis point? In other words, if you're right, then what was the point of all these other words? They were just surplusage.
Your Honor, the enumeration itself under a plain language analysis appears to be illustrative and not exhaustive. It's a common legislative drafting practice for the legislature to include a list of examples just to make clear that this is what they wanted most to be covered, but then to tack on something like a broad catch-all phrase, something like healthcare in this instance, where it's going to be ever evolving. There's going to be modalities in the future that they could be unimagined at the time that this was written, specifically something like CBD oil, which this court in the Schmidt case talked about being a reasonable treatment as long as a doctor is prescribing it. It's likely unimagined that the legislature was thinking of that over 3 decades ago.
Counsel, can I just ask you to look at the plain language? If we do not read this to say laboratory goods and services, words don't make any sense. Because then what it would say is for a provider to refer a person for laboratory.
It is unclear, Your Honor.
Well, it's not unclear. We can make it clear by adding goods and services to every single item on this list. Some of them are nonsensical unless you add goods and services. Chiropractic, goods and services. Psychometric, goods and services. Certainly physical therapy, goods and services is a concept that we all understand. But to exclude the words goods and services from the itemized list makes the language unintelligible.
I take your point, Your Honor, and I would respond by pointing out that if the parties are putting forth conflicting yet viable interpretations, it does mean it's ambiguous.
I don't think that's true. I don't think that's because two people read it differently necessarily makes it ambiguous. I mean, if one reading makes the language nonsensical, then that cannot be a legitimate reading of the statute. I mean, your opposing counsel made a point, and I just like your view of it. Isn't it possible that when this statute was enacted, the legislature identified areas of self-referral that they perceived to be a problem?
That is possible, Your Honor.
And that's why certain things are not included.
Our position with regard to the plain language analysis is that they did do that. They put down what they were most aware of at that time in 1993 and then added on this catch-all phrase at the end of goods and services to serve as a way to prevent circumvention in the future of other sorts of modalities evolving healthcare.
But you would have to say that goods and services applies to laboratory goods and services and also encompasses every other good and service available. You have to use it in both ways, or the language doesn't make any sense.
Your Honor, this court in the Schmidt case did talk about, again, the medicines and supplies language. There, it was held to be broad and all-encompassing, looking at the fact that the Workers' Compensation Act is remedial, and the humanitarian purpose of it is to protect injured workers. Here, it seems that if it's read that way, the way
Read
that...
what way?
That would allow this sort of referral, which seems to be the epitome of the kind of abuse that Act 44 was supposed to...
Well, we see it that way now in 2025. But when this statute was enacted, the legislature may have really decided that there were particular self-referral situations that were problematic, and they identified them.
And Your Honor, under that statutory construction analysis, I think what's most important for the court to look at is what the intention was behind this section, Section 306.
You don't get to the intention unless you can't read the language to make sense as written. And I'm struggling to get to a point where I can't read this section to make sense as written. So I'm asking you about the intention just because we heard your opposing counsel discuss it. But as I read this, I just don't see the ambiguity.
Your Honor, I would say that there are several cases in which the ambiguity was apparent and not apparent. I do think when we looked at, say, the Herald case, to me that seemed a little bit clearer. That
You thought Arrow was clear.
Not clear, Your Honor,
My dissent
but
was not
potentially...
very convincing to you.
Potentially.
Clear, maybe clear in which direction, I should ask.
Yeah.
You said clearer, right?
Sorry, Your Honor?
Did you say clear or clearer?
Clearer than this situation.
Clearer.
Potentially. Yes. However...
I agree with you if the remaining part of the statute doesn't specifically use the words drugs and pharmacy services over and over and over again, so we know the legislature understood that those words were out there and what they meant. And if they wanted to include them in that section, they would have put them in there.
Your Honor, as my opposing counsel stated, it is important to read the statute in its context, and this provision specifically. Subsection 3 does deal with referral ethics. Subsection 6...
Referral ethics, you said?
Correct, Your Honor.
Well, really, you're really plunging into the spirit, and I did ask Attorney Siegel about this stuff, but isn't it possible that if they were interested in that spirit and purpose, they just blew it? And they, you know, this is something that makes it unlawful. Why should the pharmacy bear the burden of suffering the consequences of being accused of unlawful activity when the legislature just failed to get it?
Your Honor, the harm here is the same regardless of whether this is a referral to a chiropractor or to a pharmacy.
And I understand that you want to talk about intent, but I agree with Justice Donahue, we can't get there. But, you know, if we did, maybe we would decide that the intent of the legislature was to provide a place for people in the rural parts of the Commonwealth to go to get treatment and to be able to get their medications without having to drive 40 or 60 or 100 miles to a pharmacy. I mean, we don't know. So it's kind of why we're left with the language of the statute.
And Your Honor, it seems that this court in the 84 mining case did look at this provision and say that the purpose of it was cost containment by stopping doctors from acting in their own self-interest. It wasn't only stopping doctors who are referring to chiropractors or referring to laboratory services. It was open-ended because it is the same harm regardless.
Yeah, but the big difference too in pharmaceutical services is there are separate parts of the act. We had a little bit of an argument today that cap pharmaceutical services and what you can get for payment. There are no caps for laboratory services, physical therapy, rehabilitation, chiropractic. So wouldn't that be a reason why the General Assembly might say, we don't have as big a problem with pharmacy self-referrals because there's these other provisions in the Act under the cost containment law that specifically cap that. There's no risk of charging too much and that kind of a thing.
Your Honor, they may have that thought. There's just no evidence of that.
Well, that's the big problem, the evidence that we have. I just one quick question. Notwithstanding any of the provision, let's say the list is gone, and it just says refer a person for laboratory goods or services.
Your Honor, that would be much clearer. That seems very purposeful, and it's only applying to laboratories.
So what you're saying creates the ambiguity is the additional things after laboratory.
The additional things, the comma, the fact that or is in there twice, and really the fact that the Commonwealth Court read it a certain way when it wasn't even at issue as naturally serving to include drugs, and then again reaffirm that when this case was before them below us here.
But they clearly know how to say drugs and pharmacy and are you in response to Justice Brobson, are you saying that we need to read this that laboratory goods or services would be drugs, prescriptions?
Your Honor, our position is that goods would subsume drugs the same way it would subsume
but not
durable
if it was
medical.
just laboratory goods and services. It's the list. If it was just laboratory goods and services, you would not be arguing goods includes drugs. It's the fact that there's laboratory and a bunch of other things of which drugs is not a list, and it transforms goods to drugs.
The fact that there is a list, and the list is comprehensive of wide-ranging topics across different medical disciplines, does seem to be significant here. Home infusion therapy, in a way, does sort of take us to the possibility of pharmaceuticals. Home infusion therapy, at its very core, involves taking medications at home. So we can really sort of slice it either way.
So can lab work, right? Lab work can involve injections of pharmaceuticals.
Correct, Your Honor. And going back to the purpose of Act 44 and Section 306, we know it is to cost contain and stop doctors from acting in their own self-interest. This seems to be a case where there are several different interpretations of what this subsection means. Appellant argues at one point in their brief that the iusdum generis canon is saying that these are different types of therapy. And then we have the argument that really it's just a qualifier, or that, as we're arguing here under the plain language analysis, that this is a broad, all-encompassing phrase meant to effectuate the intention of the legislature to cost contain. It's a humanitarian act. This court has never read this sort of abuse into the act.
Well, that may well have been their purpose. I may well have been their purpose, but if so, they might have blown it by adding all this language between the words for and goods or services. Because all they would have to do to soundly put this in your corner is just add the words pharmacy or prescriptions. And they haven't done that in 25 years, or 30 years, whatever it is. And to just, apropos what I said to Mr. Siegel, I think we all learned goods or services is, pretty much everything that's out there. So the fact that they didn't just say all goods or services, but put all these different categories in that very clearly exclude or do not include prescriptions is pretty glaring. I'm not sure. I guess let me put it this way. What authority do you think we have to improve upon or supplement the General Assembly's enumeration of items here?
Well, Your Honor, we're not asking for any sort of expansion of the language, really just a faithful reading in light of the intention of the legislature. We talked about medicines and supplies in the Schmidt case. The language under subsection 1 also talks about medical services. There's an argument that medical services could subsume medicines and supplies. We've seen the phrase goods and services in Keystone RX LLC, where this court held that pharmacies do not have a constitutionally protected property interest in goods or services that they dispense. So it does seem to be an all-encompassing broad phrase that was intentionally used by the legislature to cover all types of referrals that are at risk for being tainted by this kind of self-referral financial gain.
But then they could have said referral for goods or services, period.
That's correct, Your Honor.
It makes everything else that is included within this section redundant. It's surpluses.
Your Honor, I wouldn't say it's redundant. I think it's illustrative. At times, the legislature, as we talked about, may include what they are most aware of at that time as being at risk for this sort of tainting of self-referrals, and then keeping a broad, open-ended catch-all phrase at the end to take account for any evolving interpretations.
So the courts could fill in the blanks?
I'm sorry, Your Honor.
So the courts could fill in the blanks as time goes on? There are amendment processes.
Your Honor, I wouldn't say we're filling in the blanks. We're just reading with purpose here. And that, again, this really needs to be looked at against the context of cost containment, as that was the purpose of Act 44. There is a subsection in the Statutory Construction Act which says that, this is section 1922I, the court is to presume that the legislature did not intend a result that is absurd or unreasonable. So I would posit what is the difference between a self-referral to a chiropractor and a self-referral to a pharmacy?
Because there are no cost containment provisions that apply to chiropractors. There's an entire section that applies to cost containment for pharmaceuticals. And if the intention, as you keep insisting, is what we have to be looking for, that was their cost containment.
Your Honor, the cost containment does exist, but it does not take into account the fact that a doctor could prescribe a medication for longer than necessary, or that overprescription really is a risk here if financial gain is what's driving medical decisions rather than just patient wellness. And that's partially why the Safe Harbor and exceptions to the Medicare Act were adopted in the regulation here, so that there would be the ability for doctors to engage in these sorts of ventures going forward where the risk wasn't as great, and it wasn't being, these weren't being made with only financial gain in mind. They were being made, these sorts of referrals, really just for patient welfare.
Okay, we get it, and it was well argued by both sides. Thank you very much. Mr. Minner, we will adjourn until tomorrow.